Then for delivery of judgment, heading number 41, RSA 209 of 2017.
Appeal allowed. Impugn judgment and order or judgment and decree set aside in cost. Further, it is provided that the appellant has to return the amount of rupees 95,000 with interest at the rate of 9% per annum from 13th of Ashrin 1440 of the Bengali era of 2026 pending before the Court of Learned Districts as Gulaghat to the Court of Learned Districts as Tinsukia or any other appropriate court. Mr. Boyagi, Learned Counsel for the applicant, submits that the applicant is the wife of the respondent and they got married on 11/12/2019 at Gujan, Tinsukia, as per Hindu rites and ritual, and thereafter they have started their conjugal life at Gulaghat town, the native place of the respondent. And they were blessed with a child on 3/11/2021. Thereafter, matrimonial discord surfaced between the parties, and presently the petitioner stroke applicant is residing with her minor daughter at her parental abode at Tinsukia. Mr. Boregi further submits that the respondent herein has instituted MTS case number 88 of 2026 before the Court of Learned District Judge at Gulaghat. And since the petitioner herein is residing at her parental abode at Tinsukia, it is not possible on her part to pursue the aforementioned proceeding at in the Court of Learned District Judge at Gulaghat. And as such, he has contended to transfer MTS case number 88 of 2026 pending before the Court of Learned District Judge Gulaghat to the Court of Learned District Judge Tinsukia or any other appropriate court. The submission of Mr. Boyregi needs further consideration. That this is this notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks. And considering the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, further proceeding of MTS case number 88 of 2026 stands straight till returnable that list after 4 weeks.
I don't.
Number 6.
I am pinning the order dated 25/3/26. My lord, at page 106, 106. Parties are represented through their respective learned counsel heard. A petition number so and so has been filed by one Abdul Rab Sarkar under Order 21 Rule 97 with Section 151 claiming independent right, title, and possession over a portion of the defeated land measuring 17 lacha covered by so and so, situated at Revenue Village, Hatsingimari. It is the case of the petitioner that the said land was orally gifted to him in the year 1993 and that he has been possessing thereof for a long period by constructing dwelling houses and shops and by inducting tenants therein. The petitioner has further alleged that he was not made a party to the original suit and that the decree passed in title suit number so and so is not binding upon him. On the basis of such claim, the petitioner seeks to resist the execution of the decree. Peruse the petition claim raised by the petitioner relates to alleged independent possession and right over a portion of the decretal land. Accordingly, the said petition be registered as a separate misdeed case under Order 21, Rule 97, read with Section 151. Be tagged with the record of the present execution case. The petitioner has also filed a separate petition number so and so praying for stay keeping in the execution of proceeding till disposal of the aforesaid petition. Heard both sides on the prayer of for stay, it is seen that the present petition has been filed by a third party claiming independent right and position, which is yet to be established by cogent evidence. At this stage, no material has been brought on record to prima facie establish the petitioner's settled position and right as would warrant immediate interference with the execution proceeding. If the execution proceeding is kept in abeyance at this stage solely on the basis of the untested claim of the petitioner, the same would result in undue delay in execution of the decree. And on the other hand, no prejudice should be cast to the petitioner at this stage as his claim is being taken up for adjudication in separate case. In view of the above, this court is not inclined to grant any stay of the execution proceeding. Accordingly, the petition is for stay stands rejected. Peruse the case record learned counsel says. My lord, my submission is that when I filed petition order 21 rule 97 and that was admitted for hearing, it was incumbent on the part of the learned trial court to stay the further proceeding till the disposal of this petition. Because as per order 21 rule 97, this petition is deemed to be a plaint and a suit. Because if any final order is passed on this petition, that would be a decree. And against that decree, I would not be able to file a fresh suit. So my humble submission is that if the execution is decree is executed, then the very purpose of filing this petition would be infructuous. Because then it will create multiplicity of proceeding. I have to file again petition under order 21 to 99. So my humble submission is that, Your Lordship, that when the petition has been admitted for hearing and adjudication, then the further proceeding in title execution is to be stayed. In this regard, my lord, I am citing one decision of the recent decision of the Supreme Court. Para 42, page 14, my lord.
Yes.
It is settled. 25. Party, AB party, Periamal through LRS and Rajamal. Para 42, it is a settled position of law that an application under Order 21 Rule 97 may be made in respect of obstruction raised by any person in obtaining possession of the decretal property. The courts adjudicating such application have to do so in accordance with Rule 101 and hold a full-fledged inquiry to determine all questions, including questions relating to right, title, or interest in the property arising between the parties. This court in Brahmdev Chaudhary and Rishikesh Prasad Jaiswal has held that a conjoint reading of Order 21, Rule 97, 98, 99, and 101 projects the following picture. 1. If a decree holder is resisted or obstructed in execution of the decree for possession with result that the decree for possession could not be executed in the normal manner by obtaining warrant for possession under Order 21, Rule 35, then the decree holder has to move an application under Order 21, Rule 97 for removal of such obstruction. And after hearing the decree holder, the obstructionist, the court can pass appropriate orders after adjudicating upon controversy between the parties as enjoined by Order 21, Rule 97, Sub Rule 2, read with Order 21, Rule 98. It is obvious that after such adjudication, if it is found that the resistance or obstruction was occasioned without just cause by the judgment debtor or by some other parties at his instigation or on his behalf, then such obstruction resistance would be removed as per Order 21, Rule 98, Sub Rule 2. The decree holder would be permitted to put in possession. Even in such an eventuality, the order passed would be treated as a decree put under Order 21, Rule 101, and no separate suit would lie against such order, meaning thereby the only remedy would be a preferred appeal before such appropriate appellate court against such decree, deemed decree. 2. If for any reason a stranger of the decree is already dispossessed of the suit property relating to which he claims any right, title, or interest before his getting any opportunity to resist or offer obstruction on his spot on account of his absence from the place or for any other valid reason, then his remedy would lie in filing an application Order 21, Rule 99, claiming that his disposition was illegal and that possession deserves to be restored to him. If such an application is allowed after adjudication, then enjoined in Order 21, Rule 98, Sub Rule 1, the executing court can direct the stranger applicant under Order 21, Rule 99 to be put in possession of the property if his application is found to be substantial. It has to be dismissed. Such an order passed by the executing court disposing of application one way or the other under Order 21, Rule 98, Sub Rule 1 would be deemed to be a decree as laid down by Order 21, Rule 103 and would be appealable before appropriate appellate forum, but no separate suit would lie against such orders as already enjoined Order 21, Rule 101. In short, the aforesaid statutory provisions of Order 21 lay down a complete code for receiving all disputes pertaining to execution of decree for possession obtained by a decree holder and whose attempts as executing the said decree met with rough weather. Once resistance is offered by a purported stranger to the decree which comes to be noted by the executing court as well as by the decree holder, the remedy available to the decree holder against such an obstructionist is only Order 21, Rule 97, and he cannot bypass such obstruction and insist on reissuance of warrant for possession under Order 21, Rule 35 with the help of police force, as that course would amount to bypassing and circumventing the procedure laid down under 21, Rule 97 in connection with removal of obstruction of perpetrated strangers to the decree. Once such an obstruction is on record, executing court is difficult to appreciate how the executing court can tell such obstruction is that he must first lose possession and then only his remedy is to move an application under Order 21, Rule 99 and pray for restoration of possession. The High Court, by impugned order and judgment, has taken view that the only remedy available to a stranger to the decree who claims any independent right, title, or interest in the decretal property is to go by Order 21, Rule 99. This view of the High Court on the aforesaid statutory scheme is clearly unsustainable. It is easy to visualize that a stranger to the decree who claims an independent right, title, and interest in the decretal property can offer his resistance before getting actually dispossessed. He can equally agitate his grievance and claim for adjudication of his independent right, title, and interest in the decretal property even after losing possession as per Order 21, Rule 99. Order 21, Rule 97 deals with a stage which is prior to the actual execution of the decree for possession, wherein the grievance of the obstructionist can be adjudicated upon before actual delivery of possession to the decree holder. While Order 21 Rule 99, on the other hand, deals with the subsequent stage in the execution proceeding where a stranger claiming any right, title, and interest in the decretal property might have got actually dispossessed and claim restoration of possession on adjudication of his independent right, title, and interest dehors the interest of the judgment debtor. Both these type of inquiries in connection with right, title, interest of a stranger to the decree are clearly contemplated by the aforesaid scheme of Order 21, and it is not as if that such a stranger to the decree can come in picture only at the final stage after losing possession, and not before it if he is vigilant enough to raise his objection and obstruction before the warrant for possession gets actually executed against him. With respect to the High Court, has totally ignored such a scheme of Order 21 to 97 in this connection by taking the view that only remedy of such a stranger to the decree lies under Order 21 Rule 99, and he has no locus standing to get adjudication of his claim prior to the actual delivery of possession to the decree holder in execution proceedings. The view taken by the High Court in this connection also results in patent breach of principles of natural justice as obstructionist who alleges to have any independent right, title, and interest in the decretal property and who is admittedly not a party to the decree, even though making a grievance right in time before the warrant of execution is actually executed, though making a would be told of gates and his grievances would not be considered or heard on merits, and he would be thrown off lock, stock, and barrel by use of police force by the decree holder. That would obviously result in irreparable injury to such obstructionist whose grievance would go overboard without being considered on merits, and such obstructionist would be condemned totally unheard. Such an order of executing court, therefore, would fail also on the ground of non-compliance with basic principles of natural justice. On the contrary, the statutory scheme envisaged by Order 21 Rule 97 is discussed earlier clearly guards against such a pitfall and provides a statutory remedy both to the decree holder as well as to the obstructionist to have their respective say in the matter and get proper adjudication before executing court, and it is that adjudication which subject to the hierarchy of appeals will remain binding between the parties to such proceedings, and separate suit will be barred with a view to seeing that multiplicity of proceedings and parallel proceedings are avoided, and that gamut laid down by Order 21 Rule 97 and 103 would remain a complete code and role and sole remedy for the concerned parties to have their grievances once and for all finally resolved in execution proceeding themselves. A reading of Order 21 Rule 97 clearly envisages any person, even including the judgment debtor, irrespective whether he claims derivative title from the judgment debtor or set up his own right, title, or interest, dehors the judgment debtor, and he resists execution of a decree, then the court, in addition to the power under Rule 35(3), has been empowered to conduct an inquiry whether the obstruction by that person in obtaining possession of immovable property was legal or not. The decree holder gets a right under Order Rule 97 to make an application against third parties to have his obstruction removed, and an inquiry thereon could be done. Each occasion of obstruction or resistance furnishes a cause of action to the decree holder to make an application for removal of the obstruction or resistance by such person. My lord,
Mr. Jain, you see, this proposition is laid down in the case of Brahmadev Chaudhuri.
yes, it is before amendment.
Mm.
After amendment,
Mm.
even the obstructionist or stranger can file the petition under Order 21 Rule 97 before execution of the decree.
Mm. Our issue is whether the trial court committed any illegality while declining to stay the execution proceeding.
My
That is
sub-
the issue.
my submission is, humble submission is that when the trial court admitted my petition,
Hmm.
observing that
No,
I am
no.
claiming
Mere
independent,
admission is not a condition precedent for granting stay.
yes, because when my petition is admitted and separate Miss J case has been started,
Hmm.
that means the court has taken my petition for conclusion of the trial, conclusion of that petition.
No, you
And
tell
in the
me,
meantime,
is
in
there
the mean-
any decision on this point that after admission, the trial court has to stay the proceeding,
no,
execution
after,
proceeding?
after execution is, decree is executed
Hmm.
and I am dispossessed, then my petition become infructuous.
Hmm.
What is the merit of that petition? When I am being dispossessed from my land and
No, you see the direction issued in the case of Periamal by the Supreme Court.
yes, madam.
Here it is stated that a departmental proceeding will be initiated against the presiding officer if he failed to execute the decree within a period of 6 months.
That means the Honorable Apex Court has stated that these petitions under Order 21 Rule 97
Hmm.
has to be disposed of within 6 months,
Hmm.
within 6 months, or as early as possible.
Hmm.
Then the decree can be executed. It cannot be take pendency for a long period.
Hmm.
So my humble submission is that at this stage, the Honorable Court can direct the trial court to dispose of my petition as early as possible, or within a statutory period or a period directed by this Honorable Court. And during that period, decree is to be stayed. Execution of the decree is to be stayed. Otherwise, I am helpless. I have to again file the petition under Order 21 Rule 99
Hmm.
for the same cause of action.
Hmm.
So my humble submission is that, again I am repeating at the cost of repetition, that till that period, court can direct the trial court that this petition is to be, in all respect, is to be concluded within a period 6 months, 4 months, or 3 months, whatever the direction is issued by the Honorable Court.
Yes, what is your submission?
So,
Okay.
filing and accepting of a third party petition doesn't give an automatic right of stay of the execution proceeding. There is no such right, as my learned brother is submitting, that after accepting or admitting for hearing this third party petition under Order 21 Rule 97 gives an automatic right to the third party petitioner that the execution proceeding should have been stayed. This is wrong submission, Lordship. First of all, the third party petitioner Lordship has to convince the executing court regarding the prima facie right of his independent right. The executing court will decide whether the third party petitioner has a bona fide independent right over the suit land. But his miserably failed before the landed executive court to show a prima facie case that he is having a independent right over the suit land. Lordship, kindly find their own petition, Lordship, kindly, for a moment, Lordship. Lordship will surprise to see the proxy litigation has been sponsored by the judgment debtor. This execution petition has been pending since Lordship since 2016, Lordship. Only 10 years has already been elapsed. And execution proceeding has been pending since last 10 years, 2016. And Lordship, after the demarcation of Dhubri district, a newly district, South Salman Mankasar district has been created, Lordship. And that is why a new judiciary has been established in Mankasar district, the South Salman Mankasar district court. And after that, Lordship, the execution petition pending before the landed court at Dhubri district, Dhubri court, that was transferred to South Salman district. And here, that same petition, same execution petition, title execution petition number 30/2016, after transferring to the Executive Court at Salman Mankasar, it has become title execution petition 3/2025. So, Lordship, by seeing execution petition 2025, it's not that the execution has been.
No, on what basis you are submitting that this proxy litigation is sponsored by the judgment debtor?
Judgment debtor, Lordship, I am.
How, on what basis?
Lordship, I am demonstrating this
From?
from their own petition. They have filed their third party petition.
In which paragraph?
Page 97.
Please, Lordship, I kindly find this 99, Lordship. Their own petition, their third party petition, Lordship.
Yes.
Lordship, paragraph 2, I'm starting from the OFI, the distance I'm starting from. The distance from the house of the OFI, that means myself, to the house of the petitioner, that is third party petitioner, was about 200 yards. 200 yards, hardly 180 meters. The pro forma opposite party used to visit the matrimonial home of the degree holder frequently. While he saw the petitioner being unable to engage in any business to earn his livelihood, but the petitioner disclosed that he had got no premises. Accordingly, the pro forma opposite party orally gifted 17 lessons of the scheduled land deed out of love and affection to the petitioner on so and so. On the day of Idul Fitr, so and so. Lordship, here he claimed that the suit land was gifted to him in the year 1993. In the year 1993. And he also disclosed here that during that point of time, he didn't have any shelter house, any premises, because as per his submission, his disclosure, he was homeless during that period of time. But Lordship, second best Lordship, kindly come. Page 101. Paragraph 5. That the petitioner has been living there by constructing dwelling houses since 10/6/1986. In 1993, Lordship, when he claimed that the suit land has been gifted to him as because he was homeless during that period of time, that point of time, that opposite pro forma party has gifted that land. But next, subsequently, he stated that on that portion of land he was residing since the year 1986. So he himself conflicting his own position, own status. This shows his malafide. And another thing, Lordship, he claims that his residence and my residence is 200 meters, 180 meters, means 200 yards distance. 200 yards distance means this litigation has been continuing, Lordship, since last 27 years. During that period of time, it is difficult to believe that he was not aware of the litigation was going on. And only 2026, he came to know that this execution proceeding has been started, and he surfaces as a third party just to stop the execution proceeding. And another submission, Lordship. So he was well aware. He was well aware about the litigation going on. Just to stop this execution, he is surprised as a third party, Lordship, because his submission in the petition itself is contradictory. Lordship kindly. My Lordship kindly come to page 103. Their prayer, Lordship kindly see their prayer. Number 2 prayer, a decree declaring that the judgment and decree passed in title should number so and so is illegal and illegitimate. If this is their prayer in the execution petition, it is beyond the scope of the executive court. Executive court can't go behind the decree, can't declare a decree null and void. So their option is to go for separate suit.
How I can,
I am,
sorry,
my learned brother will get time to
Sorry.
make their submission. Lordship kindly come to their prayer in this instant revision petition, Lordship. In the instant revision petition. Page 22, Lordship kindly.
Mhm.
It is further prayed that the pending disposal of the rule in the interim, your Lordship will be graciously pleased to stay the further proceeding in with the case number so and so. With the case, Lordship, their petition has been registered as a mistake case number 41 2026. So they have prayed before this honorable court to stay their own petition pending before the executive court. Once they have submitted the third party petition, they have submitted themselves before the executing court to adjudicate their rights. Now they have approached this court and prayed that their own petition has to be stayed. Is it not contradictory and malafide?
No, there is also another pair. The title execution case number 3 of 2025.
Maybe that may be, but their petition to adjudicate their third party rights can be continued.
Mm.
And filing a third party petition doesn't give an automatic right of a stay. And Lordship, kindly. This matter, Lordship, another important thing, Lordship, this matter has been, the decree has been given in favor of me, plaintiff. In the trial court, I was the plaintiff. And it was, first appeal was filed, that was also upheld in my favor. The decree was upheld. And they again came to this honorable high court, filed a regular second appeal. And that Lordship, my Lordship authored that decree of the second appeal, judgment of the second appeal. And against that judgment, Lordship, they went to the honorable apex court. They filed the SFP there. That was dismissed. And again, that dismissal, Lordship, they have filed a review petition. And that was also dismissed. I have brought this record on record, Lordship. So that was their division petition, Lordship, also dismissed. Now, after that dismissal, then I approached this earlier executing court at Dhubri, Lordship. After clearance from the Honorable Apex Court, I approached before the earlier executing court at Dhubri, and they filed a petition praying for continue the execution, but they have told me that the case record has already been shifted to the newly created district court at Makassar. So you have to approach the Makassar court. And then I have filed a transfer petition also. Accordingly, they have transferred the case records to the Makassar court. And when this case report is at Makassar court, their Lordship, the execution case number 3, 2025 started, Lordship. This is the records question. My learned brother, Lordship, very unfortunate to say that his honorable apex court was not mentioned in his petition. was suppressed by him.
So you have filed your objection petition. You have filed your objection petition. When?
Yesterday. Yesterday.
Yesterday, already. Not less than record.
Lordship, another thing, Lordship, this third party claiming right under Lordship, the resolve who happens to be the pro forma dependent in the title suit, Lordship. His land, Lordship, the suit land was entirely gifted to me. And that position has already been established before the trial court, right up to Lordship Supreme Court. So the status of the pro forma dependent under whom he is claiming right has already been settled. It has attained finality, Lordship. So he's barred by the principle of res judicata, Lordship. Although he's a pro forma dependent, then also he's barred by res judicata. As because, Lordship, plaintiff attacked the interest of the pro forma dependent, and there is a conflict interest amongst the dependent, Lordship, because the principal dependent, they have a conflict of interest with the pro forma dependent, and Lordship, the plaintiff, I mean myself, Lordship, I attack the interest of the pro forma dependent. And that is why, Lordship, in this instant case, Lordship, the pro forma dependent will hit by the principle of res judicata. And he is bound by the judgment of the title suit that has been affirmed by the Honorable Apex Court. Because he is claiming under pro forma dependent. And another thing, Lordship, Lordship, in the revision petition, there is not any practice of filing, Lordship, affidavit in opposition. But during the last hearing, Lordship, in this instant revision petition, Honorable Court directed me to bring those Supreme Court's order on record. That is why I have filed a affidavit in opposition, Lordship. This is on record. Yeah, Lordship, in affidavit in opposition, I have annexed, Lordship, Sita copy and Jamabundi and landholding certificate. Everything I have annexed there in my affidavit in opposition. If my learned brother claiming that his name was recorded in the year 1995, as the land was gifted during the year 1995.
No, that is not the issue before this court right now.
Hmm.
Now we
Very
are testing
limited.
the order of rejection of stay by the trial executing court.
To that point.
Limited issue.
Lordship, I am coming to that point. This revisional court only interferes with the order of the learned court below when there is a failure of exercising jurisdiction or exercise jurisdiction beyond authority. There is infirmity or illegality of any order by the Lordship of the learned court below. But here in the instant case, Lordship, is the order. It's a very reasonable order. There is no infirmity or illegality. Kindly come for a moment, Lordship. What page 107? Paragraph 6, Lordship.
There he is on like,
Paragraph 6, Lordship.
yeah,
Yes.
he is on like.
It is seen that the present petition has been filed by a third party claiming independent right and possession, which is yet to be established by cause and evidence.
Yes.
You are supposed to produce cause and evidence to show his prima facie case of independent rights. And whether he has a prima facie case of independent right or not, that is the domain of executing court. This is not the domain of this honorable court. This honorable court will say whether they have exercised jurisdiction beyond authority or they have failed to exercise jurisdiction. But in this order, Lordship, in the case of it, Lordship, there is no infirmity, no illegality. The learned court, executive court will have give a reasoned order. Here, the instance petitioner settled position of such right as would warrant immediate interference with the execution proceedings. As because he failed to show a prima facie case before the learned executive court. That is why court decide is to be fit not to stay the execution because their right has been was being adjudicated in a separate case with the 41 2025. So their right will be protected. So there is no illegality or infirmity in this order. Lordship.
Okay,
And
okay, all
another
right.
thing, Lordship, another thing, the judgment debtor, he is not a judgment debtor, he is a third party. The judgment debtor petition is also is under consideration, is under adjudication by this honorable learned executing court. That is why although writ of possession has been issued in the year 2025, Lordship, it is not yet implemented, it is not executed. So there is no case of, there is no necessity of staying the execution proceeding of this on court below because they are adjudicating the petition of the judgment debtor. Okay, and it is under consideration. The next date is on 31, Lordship, of this month, 31, for hearing of objection petition filed by the decree holder, Lordship. In this regard, Lordship, so his third party is quite well aware about the proceedings that has been going on since 2000, since 1997, so almost 30 years. And he has been residing closer to my residence. So it is very difficult to believe that he was not aware of the proceeding going on regarding that suit land. But during this long period, he didn't take any action against to protect his rights. Only when the execution proceeding is supposed to be executed, then only he resurfaces as a third party. So in this regard, Lordship, latest judgment of honorable apex, Lordship, kindly. In this regard, Lordship.
Yes, yes, yes.
I have highlighted for Lordship.
Citation, please.
So belated objection by third party cannot be entertained. While he was all along walking with the degree holder and sitting alongside the degree holder. This is clearly stated in that judgment.
Okay,
Another thing, the learned brother has relied upon the judgment of honorable apex for the 2025 Supreme Court SC 461.
Hmm.
I am also relying on that judgment, Lordship. I am taking my Lordship at paragraph page 28, paragraph 42.8.
Paragraph number 42 point.
42.8, my lord.
No, here, paragraph number 42.8. 42 point or 43 point?
This.
Yes, in this case. Okay, 8 lakh.
Page 28.
Hmm?
It's 28, paragraph 42.8.
No, in fact, this is paragraph number 73. This paragraph number 42, it is quoted from Rahul S. Shah.
Lordship. This is a guidelines laid down by the apex court for the High Court across the country.
Which paragraph is relevant to you?
42.8. Lordship.
8.
Page 28. Lordship. Where is it, Lordship?
No, this observation in respect of
Third-party petition.
Order 21, Rule 97.
Third-party petition is
No, 47. His petition is under 97.
Here, Lordship, the court says that the court exercising jurisdiction under section 47 or under order 21 CPC must not issue notice on an application of a third party claiming right. So in case also, petition number 47 is going on, and that petition he has filed third party petition under order 21 rule 97. Lordship. So here, the must not issue notice on application of third party claiming right in a mechanical manner. Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of suit if due diligence was exercised by the applicant. This direction completely applies in my case also, because he is claiming right under a pro forma defendant, and pro forma defendant gifted the entire land to me, and that was established before the court, the trial court right up to the Lordship apex court, and he was remain silent. So that issue could have been raised in that trial, Lordship, but he didn't raise that. Now he speculated from raising this issue, Lordship, as per this direction, Lordship. Court is not duty bound to issue notice, Lordship, as soon as the
Okay.
third party petition.
Okay. Mr. Zain, you have any reply?
Yes, I will reply. First thing is that your lordship has rightly said that we have limited scope, whether the execution proceeding was to be stayed or not on the merit of my petition. My merit on my petition will be decided by the trial court at the time of adjudicating petition under order 21 rule 97. First thing. Second thing, my learned friend repeatedly said that I was approached the Supreme Court so I have not approached the Supreme Court at any time. Neither was party to the main suit. Those were different defendants. I was not party. And third, Your Honor, yes, my residence is 200 yards away. Whether it is guaranteed that I will know what he is doing and when he is doing, it is, and he has not disclosed the source of my knowledge, that I had knowledge about the proceeding in the title suit. So these things will not come in at this present stage. These will be decided by the trial court, whether I have cogent evidence or not, because it is my plaint, and at the plaint, and that is admitted for hearing by the trial court, because Miss J case has been registered. And at this stage, if my Miss J case has been registered, parallel trial is going on my case is to be taken up and that execution proceeding is going on and he will dispossess it. Then very purpose of filing the petition will be infectious and a futile exercise. Again, I have to file the petition under order 21.
No, are you in possession of the land now?
Yes, I am possession of the land. And the trial court has observed that I have claimed right title and possession over the land. And that land was orally gifted to me in 1993 by the pro forma defendant, who is a pro forma respondent in this petition. So at this stage, my humble submission is that, as I had already humbly submitted, that the limited period is to be given to the trial court. That
No,
within
the
that,
question is as submitted by him, whether the pro forma defendant has taken any such plea in the title suit or in the appeal or in the second appeal. That
no,
he has
he
already
has not
gifted the
approached,
same
no,
plot of
he has,
land to the
he
petitioner.
has not approached us in the second appeal or the Supreme Court. He has not approached.
During trial, before the trial court also, he has not disclosed.
Yes.
He has not taken such a plea.
Yes.
So it is completely a new plea before the
Before the
executing
executing
court
court.
now. Okay. Okay, we'll pass the order. Right now, this his objection petition is not before the court. We will call for it and we will pass the order.
My lord, interim order may continue. Interim order may continue.
No, today we will pass the order.
Public.
Yeah, this was not correct. The view to the hard response. Okay, we'll pass the order.
Yes, sir. Item 42.
May I please the Lordship? Lordship, respondent herein are the husband and wife, and out of a compromise settlement in a matrimonial dispute, a title execution has been filed by the respondent number 1 against respondent number 2, and that has been pending before the learned district judge Tinsukia. In that case, Lordship, the respondent number 2 has sold the land to me. I am the petitioner and objector in the execution proceeding before the valid attachment order under Order 21, Rule 54, Lordship. Attachment order has valid order of attachment has been passed on 15/6/2026, and the land has been sold to me on 15/11/2025, Lordship, before the attachment order. Therefore, when I have got the knowledge, Lordship, about the auction sale, I appeared before the executing court and filed a petition under Order 21, Rule 58 of CPC. That I am the objector and I have bona fidely purchased the land, and the land is not for any auction sale, Lordship. And the learned trial court, executing court, has dismissed my petition summarily, Lordship. That is bar under Order 21, Rule 58. Lordship may kindly peruse Order 21, Rule 58.
Where is the impugn order?
Impugn order, it starts from page 107, but the operating part at page 115 from last paragraph, Lordship, operating part. As from the entries, facts revealed from the records, and upon hearing the learned counsel for the degree holder, it is apparent that the sale with the present petitioner were executed to defeat the legitimate claims of the degree holder, and from the record itself, the fraudulent actions of the judgment debtor gets reflected, and no further proof is necessary to establish fraud that has been displayed at the instance of the judgment debtor. Inasmuch as the vendor, the constituted attorney, was only the agent of the judgment debtor and did not have any independent rights to sell the property, as is disclosed from the sale deed itself, that Binod Singh acted on behalf of the principal. The judgment debtor Anup Kumar Singh, whose only intention was to defraud the degree holder and denied her rightful entitlements, for which this court is of the considered opinion that the vendor, the constituted attorney, had acted on behalf of the judgment debtor in respect of the scheduled properties in collision with the judgment debtor. to alienate the charge schedule property during attachment and executed the sale deed dated 15/11/2025 in furtherance of the fraudulent intention of the judgment for which this court does not find any merits in the petition submitted by the petitioner. Consequently, the same shall stand dismissed, having said that it is also held that the sale deed number so and so, as detailed above, also does not create any rights in favor of the petitioner. The proposed auction sales are now proceed in the manner as has been directed by the order dated 15/5/2026. It may be stated here that along with the petition has also preferred a petition bearing number so and so under 151 CPC dated so and so for stay of the proposed auction. However, the main petition has been disposed by this order. There remains nothing to adjudicate on the said petition. The grievances raised in the said petition having merged with the instant order, consequently the same shall be stand rejected. Now, Lordship, what order 21 rule 58 stated, Lordship?
Order 21?
Order 21 rule 58, Lordship.
Rule?
58. Adjudication of claim and objection. This provision is special provision, Lordship, only for an objector, third party, which have right on the auction attachment property, Lordship, not for others. Adjudication of claims to or objections to attach of property, where any claim is preferred to or any objection is made to the attachment of any property attached in the execution of a decree on the ground that the such property is not liable to be attachment. The court shall, it is a mandatory provision, Lordship, court shall proceed to adjudicate upon the claim or objection in accordance with the provision herein contained. It must adjudicate, Lordship, provided that no such claim or objection shall be entertained, where before the claim is preferred or objection is made, the property attached has already been sold. In my case, Lordship, the attachment property has not been sold yet. This is on my position. And secondly, where the court considers that the claim or objection was designedly or unnecessarily irrelevant, court can summarily dismiss it, Lordship, when the attachment property was already sold and the petition has been filed after a long period of time. But in our case, Lordship, the learned executing court, nothing has been mentioned about the delay. The executing court only gave weightage on the fraud committed by the judgment debtor upon the court, Lordship. All questions, including question relating to right, title, and interest in the property attached arising between the parties to a proceeding or their representative under this rule and relevant to the adjudication of the claim or objection shall be the mandatory provision, Lordship, determined by the court dealing with the claim or objection and not by separate suit. There is a bar of separate suit, Lordship. If I am the objector and I cannot file a separate suit if I have right on the scheduled property. Upon the determination of the question referred to in sub-rule 2, the court shall, in accordance with determination, allow the claim or objection and release the property from attachment, either wholly or to such extent as it thinks fit, or disallow the claim or objection, or continue the attachment subject to any mortgage, charge, or other intent in favor of any person. Pass such order as in circumstances of the case it deems fit. Where any claim or objection has been adjudicated upon under this rule, the order made there shall have been same force and be subject to the same condition as to appear otherwise as it were decree. If my petition was adjudicated upon a complete hearing, Lordship, and I was allowed to adduce evidence, that would have been a decree. But the learned executing court dismissed my petition summarily, Lordship. Therefore, we have preferred this revision petition that for the learned executing has committed jurisdictional error, Lordship. In this regard, Lordship, I will like to prefer a judgment of this honorable court, Lordship. 1991 2 GLR 446. Paragraph 6, Lordship. It has been held by this honorable court, paragraph 6, Lordship. May I read it? I have considered the submission of the learned counsel. I have also perused the provision of under order 21 rule 58 and 59. It appears that the scheme of adjudication of the claims to or objection to attachment of property contained in rule 58 to 63 of order 21 of the CPC underwent complete change by the CPC Amendment Act 1976. Earlier, the scope of inquiry under 21 rule 58 was very limited and was confined to question of possession only. But this is not the position after the amendment of 1976. By the said amendment, new rules 58 and 59 were substituted and rule 60 and 63 omitted. The adjudication under the present order 21 rule 50 is no longer a summary. It is the intention of the legislature that it should be decision as if rendered in a regular suit, resulting in an appealable decree. In view of the amendment provision of Order 21, Rule 58, filing of a separate suit is barred, and all questions relating to the title and interest of the property attached have to be decided and adjudicated only in the claim proceeding and not by separate suit proceeding. This position has also been held by the Honorable
When the next date is fixed?
on today,
Date for auction sale?
Lordship.
Date for auction sale?
Today is the date for auction sale, but no notice has been given to me, Lordship, till now. We have immediately filed this revision petition, Lordship, after the order. And there was a summer application, Lordship. Last day it was filed.
Then why don't you mention the matter on the very first day?
Lordship, I was out of station. That's why, Lordship. The difficulty. It was filed on the holiday, Lordship. On 13th of June. There's also a judgment of the Supreme Court, Lordship, in this regard.
Hmm?
There is a Supreme Court judgment in this regard also. Order 20 and Rule 50. 2008. 2008 14 SCC 258. Relevant para 26 and 27. Yes, today is the date they are fixing for report, Lordship, not for auction sale. From the report of the Nazir. Because the Nazir has to issue notice to me.
Okay, then we will fix the matter on next Monday.
Next Monday, Lordship.
Next Monday.
Till that period, Lordship, some relief may be granted.
No.
But there is a mandatory provision, Lordship. Order 20 and Rule
Maybe
58.
we'll go through the provision. We'll list the matter for further hearing. Art Mr. D. Coleta, Learned Counsel for the petition. In this petition under Article 227, the petitioner has challenged the order dated 25th of June 2026 passed by the Learned District Judge Tinsukia in money execution case number 35 of 2019, arising out of matrimonial dispute between the respondents, and thereby rejected the petition filed by the petitioner under Order 21 Rule 58 of the Code of Civil Procedure, along with the petition filed under Section 151 of the Code of Civil Procedure. List the matter on next Monday for further consideration.
Lordship. Oblige, Lord.
Pending item 3.
So Pandya, I have gone through the.
Yes, Lordship, I went through the judgment. Para 37 of the judgment in particular is very clear, then an appeal should be preferred. Only that is the way provided by the apex court for. So in the view of that, I will withdraw the matter. Your Lordship.
Pardon?
I wish to withdraw the,
Okay.
with liberty to file under relevant provisions.
Okay. Heard Mr. Pandya, Learned Counsel for the petitioner. It is to be noted here that this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 16/1/2025 and also the order dated 18/11/2025 passed by the Learned Civil Judge Senior Division number 1, Kamrup and Gauhati. It is also to be noted here that by impugn orders dated so and so, the Learned Civil Judge Senior Division number 1, Kamrup has rejected the petition filed by the petitioner for setting aside the ex parte order dated 16/1/2025. It is also to be noted here that it is well settled in the case of Bhanu Kumar Jain versus Persona Kumar and another reported in 2005 1 SCC. Page number 787. That when an application under Order 9, Rule 13 of the Code of Civil Procedure is dismissed, the defendant can only avail a remedy available there against viz to prefer an appeal in terms of Order 43, Rule 1 of the Code of Civil Procedure. In view of the aforementioned proposition of law laid down by Honorable Supreme Court in the case of Bhanu Kumar, Mr. Pandya submits that he may be allowed to withdraw this petition with a liberty to approach this court again by filing appropriate petition. Accordingly, taking note of the submission of Mr. Pandya, learned counsel for the petitioner, this CRP stands closed. No, CRP stands a disposal on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Much obliged, Lords.
Okay. We will resume after 5 minutes.
Item 4, orders, item number 15.
May please, Lord. In this case, my lord, I order dated, my lord, 2/6/2026, my lord. The direction was issued to the insurance company for making deposit of the balance compensation amount along with the interest. And to deposit the amount before this registry, my lord, within a period of 2 weeks, my lord. But till that, I do not know whether that money has been deposited or not. The other side is also not the present, my lord.
Go ahead. Elson? Elson? MSLA? Timing, let the council come.
Right.
Timing,
Right.
after some time.
Mhm. Oh, only typically, my lord, that's it. The name of this council has not been shown in the cause list, my lord. That may be.
Even then he will call her.
Right.
May please, Lord. My lord, I am for the appellant. As per order dated 16/5/26, I have taken the steps accordingly. But the office note dated 13/6, 13/6, yes. Sumant, I saw office note. 13/5. 13/5. 13/5. Office note 13/7 discloses that the addresses are not proper. Therefore, steps have been returned back. My lord, I have taken the steps as per my record. Therefore, I have to take the instruction from my colleague.
You obtain instruction from your client? the appellant?
I have to take instruction of my
Heard, Mr.
DK Kotoki.
Learned counsel for the appellant. None appears for the respondent on call. Office note dated 13/7/2026 indicates that notice issued to the respondent number 2567, 24/1, 24/2, 24/3, 24/4, 24/5, 24/6, 24/7, 24/8. 26B, 26C, 27, 28, 29, and 30 returned unserved with a report, insufficient address, hence returned to the sender. In view of above, it is provided that learned counsel for the appellant shall obtain necessary instruction in respect to the proper address of the respondents, aforementioned respondent, and shall take fresh step upon them within a period of 2 weeks from today, and rest shall list the matter after 6 weeks. Step be taken by speed post and also by usual process.
My lord. All right.
Item 17.
May I please your lordship? My lord, steps were taken, my lord. Service await, my lord. Then service is completed upon 1 to 5.
So then service completed here.
Then service is completed upon 1 to 5, my lord.
One,
Respondent number 1 to 5.
how many respondents are here?
My lord, total respondents were 19, my lord.
19,
90, my lord.
90.
90. Rest respondents are pro forma respondent, my lord.
Okay.
So as per order, my lord, so we have taken step upon the respondent number 1 to 5.
Hmm.
Since the main plaintiff, I mean, my lord, the main appellant, my lord, appellant number 1, he's in custody, my lord, in another case, my lord. So we could not take a step upon all the respondents at the same time because he could not bear the amount, my lord. So we had approached this court, my lord, and accordingly, this court directed, my lord, us to take steps upon the respondent number 1 to 5 in the initial stage, my lord. So since the respondents upon my lord, the respondent number 1 to 5 appeared, my lord. So the remaining respondents required to be appeared, my lord.
No, you have not taken a step upon them.
No, my lord.
Then
We require time, my lord, then. Then we require time to take a step upon the remaining respondents, my lord. By publishing a, my lord,
by paper publication.
paper publication, my lord. It will be better, otherwise,
No,
my lord,
you
they
see
are not in a
whether
position to provide the expense.
their presence is required to dispose of this appeal or not.
Yes, my lord.
Necessary. Their presence is necessary.
Not, my lord. Some of them are required, my lord. My lord,
Required.
at this stage, my lord, we require some time, my lord. We'll see, my lord.
Okay.
We have to see, my lord.
Heard, Mr.
A. Rashid, my lord.
Learned counsel for the appellant and Mr. Learned counsel for the respondent number 1, 2, 1, 2, 3B, 3C, 3D, and 3E,
4 and 5.
and 4 and 5. 4 and 5.
We have to file a affidavit, your lordship, because respondent number 4 and 5 will also expire, your lordship.
Okay.
Respondent number?
However,
4 and 5
the
Four
learned
and five
counsel for
expenses.
the respondent submits that respondent number 4 and 5 also suffered demise. You furnish the particulars to him.
Yes, yes. We have filed our.
The learned counsel for the respondent number 4 and 5 further submits that he will furnish the particulars in respect of the demise of respondent number 4 and 5 to the learned counsel for the appellant within a period of 1 week, 2 weeks, within a period of 2 weeks. The learned counsel for the appellant also submits that he may be granted some time to obtain necessary instruction in respect of taking step upon the remaining pro forma respondents. They are allowed to list the matter after 2 weeks. Cover fix it.
Oblige, your lordship. Oblige, your lordship.
Number 18.
Made the lordship, we could not take any steps upon the respondent because of we could not communicate with the client lordship. So matter may be adjourned for 4 weeks, Lordship.
Heard Miss
S.A. Khalifa.
Learned Counsel appearing for Mr. MSA.
Yes, Lordship.
Learned Counsel for the appellant. The learned counsel for the appellant submits that she may be granted some time to take step upon the respondent. They are allowed to list the matter after 4 weeks.
4 weeks, Lordship.
4 weeks. In the meantime, step be taken by speed post and also by usual process within 1 week from today.
Yeah, please, your Lordship. Lordship, this appeal is ready regarding service and record.
Pardon?
This appeal is ready regarding service and record.
Okay. Heard Mr. Vardas, learned counsel for the appellant, and Ms. B. Hazarika, learned counsel for the respondent. It is submitted at the bar that this matter is ready for hearing. So far as service is concerned. Madam, you are here. Respondent number 5. Accordingly, it is provided that LCR has been received.
Yes, yes.
Accordingly, it is provided that registrar lists the matter for hearing in usual course. It is of 25 matter.
Hello.
Number 20.
May I please, Lordship, as per office noted dated 13/7/26, Lordship, service completed, Lordship.
Service completed.
Yes, Lordship.
Heard Miss,
P. Odhikari.
learned counsel for the petitioner. The learned counsel for the petitioner referring to office note dated 13/7/2026 submits that service in this matter has been completed. Accordingly, it is provided that registrar lists the matter for admission hearing.
Okay.
Item 21.
Data details.
May I please, your Lordship? As per office note dated 9/7/2026, services upon respondent number 2 is not complete. We have taken fresh steps on 29/5/2026. So we may be allowed to take fresh steps by way of dusting.
How many respondents are here?
Res- Two,
2.
1 and 2. Yes.
You are for 1. 2 has refused to accept notice.
Yes.
No. So no step is required to be taken again. Notice deemed to have been served. We will list the matter for hearing then. LCR has been received.
Yes. Yes.
Heard Miss,
P. Talukdar.
learned counsel for the appellant, and Mr. Learned counsel for the respondent number 1. Office note dated 9/7/2026 indicates that as per report of the process server, respondent number 2 refused to accept the notice. In view of above, notice deemed to have been served upon respondent number 2. It also appears from the office note dated 3/1/2026 that the record from the learned courts below have been received. In that view of the matter, it is provided that registrar lists the matter for hearing in usual course.
May please, your lordship. My lord, in this matter, my lord, there is an office note dated 13/7, my lord. As per the office note, my lord, service upon respondent number 1 to 4 is completed, my lord. Whereas, my lord, service upon respondent number 5 is awaited, my lord. So, my lord, may grant us further liberty to take fresh steps upon respondent number 5, my lord.
But Mr. S. Das, learned counsel for the petitioner. Mr. Borders for the respondent number 1 to 4. Referring to the office note dated 13/7/2026, Mr. Das, learned counsel for the petitioner submits that he may be allowed to take fresh step upon respondent number 5. Where allowed, step be taken by speed post and also a usual process within a week from today. List
My
of
lord, TCR has also
Sorry.
not been received. TCR. As per
Whether
the
it was
earlier-
called for.
Earlier order dated, my lord. Last order. TCR was.
Is against interim order.
Yes. But scan copy may also do, my lord.
Mr. Das, learned counsel for the petitioner submits that by the order dated 10/6/2026, trial court record has been called for. And he further submits that instead of the original record, the scan copy of the record may also be called for. Accordingly, it is provided that SSL call for the scan copy of the record. List after 4 weeks. 4 weeks.
Alia.
Date? Next month. August. Any date in the month of August? Highly obliged.
May I please, your lordship?
Mm.
Lordship, as per office note dated 13/7/26, lordship,
Mm.
the service report upon respondent number 1 to 5 is awaited. Thirteen-7.
So we'll list it after 2 weeks, awaiting service report.
Lordship, there is an interim order. 7/11/25.
Heard Ms. F. Ahmed, learned counsel for the petitioner. Office note dated 13/7/2026 indicates that service report in respect of respondent number 1 to 5 are awaited. List the matter after 2 weeks, awaiting service report upon respondent number 1 to 5. Interim order passed earlier shall continue.
Deeply obliged.
Item 24.
May it please your lordship. My lord, I have filed this interlocutory application. As your lordship has was pleased to dispose a writ application and a IA by common judgment, my lord. The relevant portion of your judgment is at page, my lord, 35.
That's all right, whether service was completed or not.
Service is completed, my lord. We have also given them your lordship will get it page 37, my lord, that we have communicated everything to them. Only to consider the application as your lordship has directed in para 30. And they will they will take their own decision, my lord. And they say, my lord, when we went there, they say that our application has been put up at page, my lord, 13 and 14. 13 is the relevant portion. In view of the order passed today in WBC, so and so the IA stands disposed of. I was filed with a limited prayer to accept and consider for grant of approval of the application before the Bar Council of India for starting a new law college.
No, Mr. Buragoha, you say, by the order dated 1st of April 2026, you have been directed to take fresh step upon the opposite party number 1, that is the Bar Council of India. Whether you have taken step as per said order?
Yes. In fact, my lord, they have
Just
nothing
a
to.
note. Okay. Okay.
Because it is an order of an honorable court, and all the parties to that order is binding on that observation or by that order. my lord.
Okay.
And they are in your their Bar Council of India that was made respondent number 4, my lord.
Hmm.
They try to misinterpret the order, my lord, judgment of the Honorable High Court's order that has said that para 30, my lord, under the given facts and circumstances, I find sufficient merit the petition, in the petition, and accordingly the same stands allowed by a mandamus of this court. The respondent number 2 is directed to process the application dated so and subsequent application so filed by the petitioner college in accordance with the procedure prescribed under Regulation 4.5 of the University Grant Commission affiliation of the college by universities regulation 2009, and thereafter as per 16.1 of the rule of the legal education 2008. Only they can consider, and my lord, and they say that as the
Right.
may,
Mr. Buragoha,
my lord,
in absence of the other parties, should we hear the matter today?
only one party is necessary, that is Bar Council of India.
But
Because
in
the
original petition,
other party, university, they have implemented your lordship's order.
maybe this IA is in relation to the WPC number.
Lordship may give a short date, and their name may be indicated in the list so that they can appear, my lord. At least
Okay.
respondent number 4, Bar Council of India.
Heard Mr. Buragoha, learned counsel for the applicant. Office note dated 5/6/2026 indicates that after effecting service upon the respondent number 1, the applicant has filed one affidavit. Oh, no, by disseminate, the applicant has filed one affidavit. And it appears that the notice was duly accepted for the said respondent, but none appears today on call. Registrar list the matter on next Monday then? Monday,
Not Monday, madam. Wednesday.
Wednesday. And in the meantime, registrar will reflect the names of standing counsel of all the respondents from opposite parties. Place the matter on Wednesday. The main appeal is still pending before this court?
No, they already disposed of them, my lord.
Disposal.
Disposed of them. As they have not complied with the direction issued by this honorable court, my lord, for making payment. That's for that actually, we have filed this present petition miscellaneous petition, my lord. For giving it the direction to the insurance company.
No, on the other day, Miss L. Sharma entered appearance.
The last second she appeared, my lord. Now
Uh.
she has, they are telling me that she has not received any instruction, my lord, from the insurance company, my lord.
So then
For that-
let notice go.
No, let there be a notice, my lord.
Heard Mr. Encidas, learned senior counsel assisted by Miss Jia Ghoshal, learned counsel for the applicant. Two, on 3rd of June 2026, Miss L. Sharma, learned counsel, entered appearance for the opposite party, yet as per her submission, yet it is informed that she has not received any instruction, and she has also been not assigned to appear on behalf of the opposite party. In that view of the matter, it is provided that notice be issued to the respondent opposite party, returnable in 4 weeks, step be taken by speed post and also by usual process within a week from today. Additionally, dusty service is also permitted.
Right.
After effecting service upon the opposite party by dusty mode, the applicant shall file an affidavit before this court list after sorted. 3 weeks. 3 weeks. Third of us.
Remember? 25.
I have taken steps, my lord, to the sole respondent, my lord. So the transfer petition, my lord, filed by the wife, my lord.
So the notice issued to the respondent return with a report that no such person, RTS.
But in the lower court below, he appeared, my lord.
Heard Mr. H. Das, learned counsel for the petitioner. Office note dated 13/7/2026 indicates that notice issued to the respondent by speed post returned with a report, no such person, RTS. The said office note also indicates that process server's report has not yet been received. So do we wait for the report of the process server?
Yes, my lord.
List the matter after 2 weeks awaiting the report of the process server.
Interim order.
Interim order pass earlier shall continue.
Publish.
May I please your lordship? As a transfer petition, we have taken steps, but the office note dated 13/7/26 shows that the respondent has sold the house and land.
So you obtain instruction in respect of his new address.
Lordship, I being the wife, I know he is residing in Itanagar, his working place there, and he's living with his parents, lordship there. So I can send to that address also. I may be directed to take the steps towards that address, lordship.
Okay. Heard Mr. Hendrik,
KK Henry, lordship.
learned counsel for the petitioner. Office note dated 13/7/2026 indicates that neither edit card nor answered notice returned till date. In respect of the notice issued to the respondent. Said office note also indicates that the process server's report has been received by the section, and the said report indicates that the respondent has sold his house and land and left the address and moved elsewhere. The learned counsel for the petitioner submits that as per his instruction, the petitioner is presently working at Itanagar
Itanagar,
along with his parents,
lordship.
and he submits that he may be allowed to take step upon his new address. They are allowed step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Deeply obliged.
Item 27.
You have put a respondent. So he has service completed then,
Service completed, my lord. Hearing may be fixed, my lord.
hearing that. Heard Mr. Hussain, learned counsel for the petitioner, and Mr. T. Mazumdar, learned counsel for the respondent. It is submitted at the bar. This matter is ready in respect of the service. Accordingly, it is provided that rest shall list the matter for admission hearing. So do we fix a date?
Yes, your lordship.
Okay,
On 10th of
10th of August. Caveat is there, caveat would be heard, caveat stands to be sirs.
item 28.
Being your lordship, I am appealing for both the respondents. Need at least 4 weeks time to file my affidavit.
None appears for the petitioner on call. However, miss, your name please?
T does.
T does, learned counsel for both the respondent present. Miss does submits that she may be granted 4 weeks time to file objection. Fair allowed to list the matter after 4 weeks. And in the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 29.
Please, your lordship. Lordship, service is complete.
Service completed.
Service complete.
Heard, Mr.
HR.
A.J. Ahmed, learned counsel for the petitioner, and Mr. Porua, learned counsel for the sole respondent. Sole respondent.
Interim shall
Since
be continued.
service in this matter has been completed, rest shall list the matter for admission hearing on
On 12th August.
12th of August,
After 12, maybe from.
after 12,
On 21st August.
or 21st.
Interim shall be continued.
Interim order parcel shall continue.
Item 30.
It is your lordship.
As per office note dated 13/7/26, it is seen that our respondents have refused to accept the notice. So service may be deemed to be served upon them.
Okay. Heard, Mr.
BS Dekage.
Learned counsel for the petitioner. Office note dated 13/7/2026 indicates that respondent number 124 refused to accept the notice. In view of above notice deemed to have been served upon respondent number 124. Justice shall list the matter for admission. Hearing on.
Interim order may be continued. Interim order may be.
Interim order passerly shall continue.
Item 31.
May I please your lordship? Lordship's service is awaited. Interim may be extended, lordship.
Heard, Mr.
R. Mali on behalf of S. Das.
Learned counsel appearing on behalf of Mr. S. Das, learned counsel for the petitioner. Office note dated 13/7/2026 indicates that respondent number 2 and 3. Notice issued to the respondent number 2 and 3 returned with a report. Not found. Address it. Return to sender. Accordingly, it is provided that the petitioner shall take fresh step upon respondent number 2 and 3 by speed post and also by usual process after obtaining necessary instruction in respect of their address. The said office note also indicates that neither edit card nor answered notice issued to the respondent number 1, 4, and 7 returned till date. List the matter after 4 weeks, awaiting service report upon respondent number 1, 4, and 7. You take step upon respondent number 2 and 3.
Obliged, lordship. Lordship, interim may be extended.
Interim order pass earlier shall continue.
Much obliged.
Item 32.
And appeared on behalf of the full respondent minor. Lordship may allow him to minor file detention, otherwise my 10 lakh should be pending.
Pardon?
He has taken a 10,10,000 for giving the land, but till today, my lord, the money should have filed. Due to when he has not appeared, WS was my lord not allowed to file, but I have no objection to allow him to file my lord, WS, my lord. Otherwise, I will be suffer, my lord.
So we can dispose of this petition.
Yes,
Because the input order, your lordship will find, my lord. The exporter order was set, aside, my lord. That's page 25.
Page 28.
Hmm. 28.
28, my lord.
Last my lord, however, record reveals that last period of the lord.
The exporter order dated 30/4/20 was passed against the defendant is vacated. However, a record reveals that the statutory period of filing a written statement was over from the date of service of summons, as defendant is allowed to contest the suit without any written statement. That we are agreed by that part. Because
Of the is now stay my lord, so.
Okay. Heard Mr. Kotuki, learned senior counsel assisted by Ms.
And Kashyap.
Learned counsel for the petitioner and Mr. Bora for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 21st of August 2025 in Manisuit number 3 of 2025, passed by the learned
London Civil Judge
Civil
Senior
Judge Senior Division Vishwanath. Mr. Kotoki, learned counsel for the petitioner, submits that the petitioners that the petitioner is the defendant in money suit number
3 of 2020.
3 of 2025 and by it impugn order dated 21st of August 2025, the learned trial court has allowed the petitioner to contest the suit. However, barred him from filing his written statement. And being aggrieved, the petitioner approached this court by filing the present petition. Why you could not file the written statement?
Because I was actually, my lord, at the time I was having treatment at Chennai, my lord. I went for, I was having.
Where is the relevant document?
Yes, that has been enclosed, my lord. That has been considered by the court below, my lord. Your lordship goes to record, my lord. Order, she reveals, my lord.
Mr. Kotoke, learned counsel for the petitioner, submits that at the relevant point of time
that your lordship have page 27, my lord.
herein was undergoing treatment at Chennai, for which he could not file a written statement in time. And unless he has been allowed to file the written statement, he will suffer serious prejudice, and on such count he has contended to interfere with the impugn order dated soon. Mr. Bora, learned counsel for the respondent, submits that he has no objection in the event of setting aside the impugn order dated so and so. Accordingly, considering the submission of learned counsel for both the parties, the impugn order dated so and so stands set aside and closed. You have enclosed your written statement with the application?
No, that. We'll file it.
Yes, man, sometimes they appear and again they left, again they appear, they're delayed.
Anyway, we'll.
Specific time may be given. Otherwise, I have to suffer. 10 lakhs, 10,000, I'm taking
Okay.
loan.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that the petitioner shall file his written statement within 1 week or 2 weeks.
2 weeks, man.
Within a period of 2 weeks from today. And on such written statement being filed, the learned trial court shall take the same on board and proceed to hear the matter in accordance with law. Both the parties are directed to appear before the court on 24th of July.
24th, yes.
24th of July.
Number 33.
Services completed.
For number 3.
Correspondent. Okay.
It will be fixed for admission hearing because the matter relates to filing of additional written statement. If the by last order by the Honorable Court, the suit has been stayed, 100%. So, but if not inconvenient, can it be on 27th of September, July?
July. Okay. Heard Mr. D. Coletta, learned counsel for the petitioner, and Mr. K. Agoral, learned senior counsel, assisted by Ms. Learned counsel for the respondent. It is submitted at the bar that in this matter service is completed and the matter may be listed for admission hearing on 27th of July of this month. 27th of July. Accordingly, it is provided that recess shall list the matter on 27th of July for admission hearing. Okay. On that day, an endeavor will be made to finally hear and dispose of the matter. Interim order pass earlier shall continue.
24.
May it please your lordship, it has been seen in the office note that due to insufficient address, this notice was not served. Lordship may allow us to take fresh steps.
Heard, Miss?
S. Sharma.
Learned counsel for the petitioner. Office note dated 13/7/2026 indicates that notice issued to the respondent returned answer with a report that insufficient address, RTS. The learned counsel for the petitioner submits that she may be granted some time to obtain instruction and to take fresh step upon the respondent. Where allowed, recessal lays the matter after 6 weeks,
Lordship, 3 weeks.
3 weeks. No, you have to take step
Lordship, after 4 weeks then.
after 4 weeks. After 4 weeks, step be taken by speed post and also by usual process within 1 week from today.
Obliged.
Items 35 or 36.
Position not.
Milods, in this IA, as per the last order, Milods, they have taken time on the last occasion to file the affidavit in opposition to our IA and to submit it before 15th of July. Milods, the only reason that I'm pushing Milods is because this is Milods, we want to asking for an prayer in our IA. Milods, because this is a matter where I'm not being able to see my 6-year-old son because this matter arises from a interim visitation order matter, Milods.
You have not been sick for the respondent. Opposite party, Mr. Sheikh submits that he may be granted 4 or 5 days time to file his objection. Where allowed, recessal lays the matter on. Okay.
Next week, madam. 24th July.
24th July.
24th July.
I'm obliged.
Item 37.
May it please your lordship. Lordship, as per the office note dated 37, neither ID card nor answer notice has been received back.
Heard, Mr.
D. Hazarika, lordship.
Learned counsel for the petitioner. And Madam, you for?
For respondent number 5A, 5B, and 5C.
Respondent number 5A, 5B, and 5C. Office note dated 13/7/2026 indicates that neither ID card nor answer notice issued to the respondent number 1 to 4 and 6 to 2020, no, 6 to 23 received by the section till date. Place the matter after 2 weeks, awaiting service report upon respondent number 1 to 4 and 6 to 2023. After 2 weeks.
Obliged, lordship.
Item 38.
May it please your lordship. This IA Civil 1708 is the condonation application praying for condoning the delay of 18 days on the lordship in preferring the regular second appeal. The main defendant, contesting defendant already filed KV8 lordship. Objection.
Pardon?
Responding number 5, caveator.
Lordship, if they do not object to the condonation petition, lordship, may I pray to condone the delay of 14 days only? Though there are some other respondents, 1 to 4, they are the owner of the suit property. And respondent number 5 purchased the suit property. Suit was filed by the appellant for specific performance of contract.
No, that's all right, but whether you have taken any, okay. This
No,
is,
lordship,
today it
is
is
the first
listed for
date.
the first time.
First date, lordship. So only the delay is of 18 days, so I am praying if your lordship consider the case of the appellant, lordship. If they do not want to file any objection, lordship.
No, madam, without hearing the other parties, would it be proper to pass such an order?
Then Lordship may issue notice to 1 to 4, Lordship. Fixing a date, Lordship, as already in the meantime, respondent number 5 already initiated execution proceeding.
Heard Ms. R. Soduri, learned senior counsel, assisted by learned counsel for the applicant, Ms. R. Saha, learned counsel for the deviator.
Yes.
Opposite party number 5.
5, Lordship.
This application under Order 41, Rule 3, capital A of the Code of Civil Procedure, read with Section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 18 days in preferring regular second appeal against the judgment and decree dated 22nd of July 2025, passed by the learned civil judge, Senior Division, Boingao, in title appeal number 2 of 2022. Let notice be issued to the respondent opposite party number 1 to 4 by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent opposite party number 5, since Ms. R. Saha, learned counsel, entered appearance and received notice. However, extra requisite copy of the petition be filed, be furnished to her during the course of the day. List the matter on first week. Second week.
On 12th August.
12 of August.
Today is, Lordship, 6th, 15th. So after 4 weeks, your Lordship may fix, otherwise service
After
will
4
not
weeks.
pick up.
On 21st August.
Lordship, I'm deeply obliged.
Caveator would be heard, caveat distance research.
Item 39.
Yeah, please, Lord. We are praying for a substitution of the respondent number 2, 10 and 18. What happens in this case, my lord, being agreed by the order of Land Grabbing Tribunal, Ujai, we have approached this honorable court by filing, my lord, revision petition. And my lord, thereafter we have come to know from the council that respondent number 10 and 18 died. So on
Any
inquiry,
objection?
Lordship, regarding IA number 2063, the copy has been served upon us. But the rest of the IA, that is IA number 2064 and
No,
2065.
now we are taking up IA number 2064.
That copy is not with us, Lordship.
and sharp copy.
Lordship, only IA number 2063 copy has been served upon us. So that 2064 copy is not with us.
Here नाही तुम्हाला এইটোৱে দিছে আপুনি 64টোৱে দিছে নেকি এইটোহে পাইছো 62টোৱে দিছে বাকী এইটো দিয়া নাই
And
I
Lordship,
will start with
Mr.
my lord.
Torma, learned counsel for the applicant. And Mr. Singh for the respondent opposite party number.
Respondent number 10 and 18, my lord.
No, you.
Lordship, I am for respondent number 1 to 9, 11 and 12, Lordship.
1 to 9, 11 and 12. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicants for condonation of delay. How many days, Mr. Sharma?
Long delay, my lord. So we have come to know just now, my lord. That is why, my lord, it will be 2132. 2132.
2132 days in
2132.
preferring the petition for setting aside abatement and substitution of legal heirs of the respondent number 10
10
and
and 18.
18 in CRP number 155 of 2025. The learned counsel for the opposite party number so and so submits that he has not been furnished with a copy of this interlocutory application. Accordingly, Mr. Sharma is directed to furnish a copy of the same to Mr. Singh, learned counsel for the opposite party number so and so during the course of the day. Rest unless the matter on
Next week, man, any day.
next week.
Next week, any day. 27 August. 27 July. July. Obliged.
And in which IA you have not received copy?
IA number 2064, Lordship.
And
And IA number 2065. Public condition.
I'll furnish.
Itu 2065 to একে হবে।
Obliged.
Lordship, there is a small correction in page number 17, Lordship. Page 17, Lordship. In paragraph 8.5, Lordship, it was indicated that so and so case number, if any pending before the learned district judge Bozali stands transferred to the learned principal judge family court number 1, Lordship. 8.5, Lordship. Page number 17. The matter was transferred from the Court of Learned District Judge Bozali to the Court of Principal Judge Family Court number 1, Lordship. And in the paragraph 9, Lordship, inadvertently, the Learned District Judge Kamrup is written, Lordship. So that is required to be corrected, Lordship. Paragraph 9, line number 4 and 5, Lordship.
In 8.5?
8.5, it is all right, Lordship. Family Court number 1.
Okay.
That was transferred from the Court of
Okay.
Learned District Judge
Heard.
Bozali to the.
Mr. D does learned counsel for the applicant and Miss
You're right.
learned counsel for the opposite party. This interlocutory application is preferred by the applicant for correction. For correction of the clerical mistake committed in the last line of the paragraph number 9.
Yes.
Mr. Das learned counsel for the applicant taking this court through the paragraph number 9 of the order dated 6/4/2026 submits that while transferring the miscellaneous guardianship case number 4 of 2022 from the Court of Learned District Judge Bozali, it has been mentioned that the same has to be transferred to the Court of Learned District Judge Kamrup M at Gauhati. And instead of Learned District Judge Kamrup M at Gauhati, it ought to have been as the Learned Principal Judge Family Court number 1 Kamrup M at Gauhati.
Yes.
Accordingly, like any objection? No.
No.
The learned counsel for the opposite party submits that she has no objection. Accordingly, taking note of the submission of the learned counsel for both the parties, it is provided that henceforth the Court of Learned District Judge Kamrup M and Gauhati in last portion of the paragraph number 9 shall be read as Learned Principal Judge Family Court number 1 Kamrup M at Gauhati for all purposes. Let this order be part of the order dated 6/4/2026 passed and transfer petition number 93 of 2025 in terms of this IA stands closed.
I'm obliged.
Number 46.
My lord, at the instance of the respondent, this matter has come. Office note says that, my lord, the records of the appellate court has received. The record of the title suit has not been received in this case. Office note 22/4/2026.
Service completed.
Service completed. They have appeared also.
Lordship,
we find, we have already filed the Okadatnama, but we have not received the RSA petition and the sketch petition.
No.
So RSA petition and the sketch petition.
Notice was issued, how they read the.
It is a pardon.
I will, sir.
Part is the Hawk Learned Counsel for the appellant and Mr.
On behalf of SK
Learned Counsel appearing on behalf of SK Putra. Learned Counsel for the respondent. Office note dated 22nd of April 2026 indicates that LCR of TS number 1 of 2009 has not been received. Though the LCR of title appeal number 33 of 2017 has been received. Accordingly, it is provided that recusal urgently call for the record of LCR of TS number 1 of 2009 from the learned trial court. The learned counsel for the respondent submits that he has not been furnished with a copy of the memo of appeal of RSA 84 of 2025 and the IA number
IA 1681, my lord, stays
1681 of 2025 or 6. 2025. Mr. Hawk undertakes to furnish a copy of the memo of appeal of RSA number 84 of 2025 and also the copy of IA number so and so to the learned counsel for the respondent opposite party during the course of the day.
my lord. My lord, interim order may continue because.
Interim order passer shall continue. Recusal is the matter after
My lord.
after receiving the record of the trial court.
My lord.
Immediately after receiving the record of the learned trial court.
Item 47.
Lordship, this is a condonation application in filing the restoration application, Lordship. The regular second appeal was dismissed in the year 2022. 1261 days delay in filing the restoration application.
Ms. R. Sodore, learned senior counsel assisted by Ms. So learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 1261 days in filing restoration application for restoring the RSA number 239 of 2018. Let notice be issued to the respondents returnable. Respondents opposite party returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Step by both ways, Lordship. Step by both ways. Problem.
Data.
Lordship, kindly peruse the last two orders of this honorable court, Lordship, order dated 24/4/26 and 25/5.
Yes, any up to date instruction?
Your Lordship, make reference some more time, Your Lordship, because there is an instruction, not instructions, Your Lordship, but communications letter from the secretary to the director, Your Lordship, seeking some documents from us, Your Lordship. This is the communication letter of yesterday, Your Lordship, so it may take some time, Your Lordship, to give some of the documents, Your Lordship, to the deputy secretary, Your Lordship.
Key document.
Okay, please wait. Retirement.
Look, after passing the order, that is on record, I think, Lordship, order dated 24/4/2026.
Hmm.
That is flag mark, your lordship, in the record.
Hmm.
This is the communication, lordship, furnished by the secretary to the government of Assam. Now they have started the initial stage again, lordship, by this communication, lordship. They have taken, lordship, enough time only for final outcome.
Yesterday, in 7. The instructions from actually.
No, this is not in regards to creation of any post. It is only in regards to, with regards to the retention of the post.
Yes.
Yes, your lordship.
Then why the matter takes so much time? Hmm? Heard Mr. M. Khan, Learned Counsel, for the petitioner is Redampe, Learned Standing Counsel, no, Learned Counsel for the contender. No, not contender, Learned Standing Counsel for the respondents in Secondary Education Department. To Void Order dated 25th of May 2026, the respondents were directed. No, the Learned Standing Counsel for the respondent in Secondary Education Department was directed to furnish compliance report before this court. In respect of the order dated 24th of April 2026, yet producing a letter of the Deputy Secretary to the Government of Assam addressed to the Director of Secondary Education Assam, Ms. Terampi submits that by letter dated 14/7, by aforementioned letter dated 14/7/2026, the Deputy Secretary to the Government of Assam has asked for some of the document, namely number 1, authenticated copy of specific post creation letter. Number 2, copy of last retention order. Number 3, details of the period for which retention is sought. Number 4, justification for seeking retention. And when you are going to file these documents?
Lordship, within this week, lordship.
And the Learned Standing Counsel for the Respondent Authority submits that within this week they will file. They will transmit the aforementioned documents to the Secretary, to the Deputy Secretary to the Government of Assam Department of School Education. And she also prays for granting some time to comply with the order dated 24/4/2026. They are allowed to list the matter on.
Lordship, it will take some time because the document has been again referred to the finance department also, your lordship.
4 weeks.
4 weeks, yes, your lordship.
Resolution list the matter on 21st of August. Always. Okay, 24th of August.
Yes, sir.
Yes, parted.
Lordship, as per the last order dated 8/6/2026, we were directed to produce a bank statement by way of an additional affidavit. However, Lordship, our client is out of station due to some medical reasons, Your Lordship. Lordship, you grant us some time.
So I was waiting for a whole day, my lord. They could have told me in the morning itself. Good.
Have your-
Okay, when? Next week?
Lordship, 2 weeks time in the plan.
Why 2 weeks?
Lordship, because he's out of station, the client is out of station, Your Lordship.
Heard Mr. R. Chakraborty, learned counsel for the appellant, and Miss
J. Sharma.
J. Sharma, learned counsel for the respondent. Ms. J. Sharma, learned counsel for the respondent, submits that the respondent is out of station, and as such, the required information as sought for by this court by order dated 4/6/2026 could not be furnished today, and she pressed for 2 weeks' time. They are allowed to recess and list the matter on suggested date 5th of August.
Published.
Item number 9.
May I please your lordship? Last.
On behalf of respondent side, my client senior instructed me to fix a date, next date,
Pardon?
to fix a convenient date.
Last order of this court lordship 25/2026, and the court has come not settled. This court wanted to settle the matter before mediation. No settlement took place. Here on the order is their lordship shows that there is a wife on the wife side demanded 20 lakhs and husband offered 11 lakhs and not settled. So ultimately, the case is that initial case is a nullity of marriage. Subsequently, I filed the application for for the dissolution of marriage by inserting section 13(1). That amendment application rejected. Hence, I approached this on a court lordship for amendment of my application. For the conduct of the parties, appears there's a good case for dissolution of marriage also. My case is only insertion of section 13 now also. Already section 12 application, initial application was section 12(1). Subsequent amendment, section 13(1)(a). Divorce. Conduct the parties find that they are not settled the matter amicably, lordships. Both sides wanted divorce, lordships. My learned friends paid time.
It's the next date, Your Lordship.
Next week.
Next date, according to the convenience.
Heard Mr. F.U. Barbonia, learned counsel for the petitioner. And Miss, your name, please?
F. Chaudhary,
Learned counsel appearing on behalf of
Advocate M.H. Laskar.
M.H. Laskar, learned counsel for the respondent. The learned counsel for the respondent price for listing the matter in the next week.
Next week.
We are allowed to resist and list the matter on.
In interim is their lordship. Proceeding is stayed by last order. That may be continued.
Okay, interim order pass earlier shall continue.
Lordship. 24th August. 24th July. Oblige.
Item 10.
My lord, this matter is already admitted. My lord, appeal was admitted and there has been a separate miscase for interim, and interim, my lord, it was considered in the miscase, my lord. As per last order, it was. Respondent choker. My lord, the respondent have filed their Ukalandama, and while the IA was disposed of, their name was shown, my lord. But in this RSA, my lord, their name is not shown. Appeal is admitted, my lord.
Okay. Heard Mr. Sigdar, learned counsel for the appellant. Mr. Sigdar submits that the appeal has already been admitted and the interim period has also been granted in the IA, connected IA. And in this appeal, the name of the counsel for the respondent has not been reflected in the
Some M Pathak, I think, my lord.
cause title. No, in the cause list. In the cause list. Accordingly, it is provided that the registrar lists the matter. Whether a record has been received.
Well, record not received, I think. Huh? Record not received, my lord. Reminder for record, my lord, may be issued, my lord.
No, record has not been called for.
Yes, my lord. Record call karo na.
It appears that though the appeal was admitted, the record has not been called for from the learned courts below. Accordingly, it is provided that registrar call for the record of title appeal number 1 of 2022 from the Court of Learned Civil Judge Senior Division Baksa, and also the record of title suit number 06 of 2019 from the Court of Learned Monsif Baksa. List the matter after 4 weeks.
Well,
May it please, your lordship. Cause list reflected the name of Mr. R. Sharma, lordship. In this case, notice was issued, but appeal not yet admitted, lordship. R. Sharma and S. D. Sekia, their name shown. May I proceed, lordship?
No, if the council entered appearance, would it
Then one
be
chance may
proper
be,
for
lordship, one chance may be given. In
the
name
next
shown
week?
in
Next week?
lordship. Monday, lordship.
Not Monday. Wednesday or Thursday? Wednesday? Heard Miss R. Soduri, learned senior counsel assisted. by
Prepared,
Mr.
if
Ali.
possible, lordship, on Tuesday, lordship. Though it is a concurrent finding, lordship, there is a substantial question of law, lordship. If possible, on Tuesday.
Ali or Islam? Islam. Islam, learned counsel for the appellant. Though the name of one Mr. R. Sharma for the respondent is reflected in the cause title, no cause list yet. None appears for the respondent on call. In that view of the matter, it is provided that registrar lists the matter on Tuesday.
Yes, lordship. Lordship. So, lordship, as per your convenience, lordship. Only on next date, if they do not appear, then my case will be taken up for hearing.
You remind this court.
Lordship, obliged.
Remember, 43.
May it please. Your lordship, this is for admission of this. I formulated some substantial question. If your lordship have a look at those questions that is at page 5. Your lordship, what has happened basically, there are two issues. What? There was a dealership, Maruti dealership with the defendant. The defendant sold me that dealership. Now to get that sale enforced,
the dealership has to be transferred to the name of the plaintiff. I am the appellant and the plaintiff. Now, before that exercise could be done, the defendant has tendered the resignation of the dealership and Maruti have cancelled the dealership. So the agreement, our basic case was before the court below, that the agreement stood frustrated, because of which this agreement is no longer binding. Section 56 of the Contract Act. The trial court has rejected my case on ground of frustration only on the ground that there is no stipulation to that effect in the agreement. Now, the law of frustration is very clear. If your lordship goes through a Supreme Court decision also, the way back in 1953 only, if I may place that decision. Basically, that issue is decided in issue number 6, 7, and 8 of the appellate court judgment. That is at page 111. Hmm. 170. Correct. Is 6.
The appellate court has, first appellate court has affirmed the judgment and decree passed by the trial court.
Upheld.
There are concurrent finding of facts by both the court below.
Only thing is that in the trial court held that the agreement by which the dealership was transferred, that agreement was null and void.
Hmm.
That finding has not been interfered by the appellate court. Appellate court in a different says that there is no frustration of that agreement because there is no stipulation in the agreement as to what will happen in the eventuality Maruti cancelled the dealership prior to the sale coming into effect. Trial court judgment has held that the agreement is null and void because there was no consideration. If your lordship wants to go to that finding, I can just.
Page number?
I'll just. Page number 35. Issue number 6, 7, and 8. In the bottom of that page, internal page 26. My presentation might be slightly. Am I with your lordship? Page 26. From the bottom, your lordship may 1, 2, 3, 4, 5, 6, 7 line. I find that the sale date, your lordship got 7 line from the bottom.
In respect of issue number 6,
7, and 8.
I find the sale date, yes.
Dated is no agreement in the eye of law in as much as the consideration amount is ambiguously stated in the same. Then next page. 1, 2, 3, 4th line. Apart from this, Section 56, which deal with frustration of contract, only operates when there is a valid contract. This was a finding that was in my favor. That has not been interfered with, but in 678, the appellate court has gone to say that, look, he has not even interfered with this finding. He goes on a different line and says that since there is no stipulation in the agreement as to what will happen in the eventuality Maruti doesn't give me the dealership, therefore, there is no frustration of contract. My basic logic is a contract is always comes into form on a basic purpose. The substratum of the contract. Suppose I'm selling a land and the land is the substratum of the contract. Now, if the land does not exist, maybe because of land acquisition or that may not be in the contemplation of the parties at the time of formulating the contract. That is a subsequent event that the court has to examine to determine whether there is a frustration or not. Frustration does not happen only because the parties could have foreseen that event, because frustration is also there when there is an unforeseen event. So when the substratum of the contract loses out, then Section 56 comes into play, and then the court has the authority to pronounce it as null and void. That was my only case. The court has gone into the thing. If your lordship may just see the appellate court's finding, page 118. Para 24.
Yes.
Third line. The plaintiff and the defendant entered into an agreement for the sale of business of Messrs. So-and-so. I have perused Exhibit 7, wherein there is no stipulation in the agreement that the sale will come into effect subject to approval of Maruti Udyog Limited. Then he goes slightly beyond. The plaintiff cannot go beyond what has been executed between the plaintiff and the defendants, and also cannot incorporate something in the pleadings or in evidence that the sale will be effective subject to approval or permission of Maruti Udyog Limited. No stipulation can be taken into consideration if such a stipulation clause is not in the agreement. If I may place a judgment of the Supreme Court, the Supreme Court does directly say this is contrary. Judgment. Yeah, judgment of applicant. Your Lordship, I'm referring to a 1953 judgment that, if your Lordship may just see para 1, the fact in the first page, the fact giving rise to this appeal are for the most part uncontroverted, and the dispute between the parties centers around the short point as to whether a contract for sale of land to which this litigation relate was discharged and come to an end by reason of certain supervening circumstances which affected the performance of a material part of it. Then your Lordship may turn to paragraph 17. In the large majority of cases, however, the doctrine of frustration is applied not on the ground that the parties themselves agreed to an implied term, which operated to release them from the performance of the contract. The relief is given by the court on the ground of subsequent impossibility when it finds that the whole purpose or basis of a contract was frustrated by the intrusion or occurrence of an unexpected event or change of circumstances which was beyond what was contemplated by the parties at the time when they entered into the agreement. Here there is no question of finding out an implied term agreed to by the parties embodying a provision for discharge, because the parties did not think about the matter at all, nor could possibly have any intention regarding it. When such an event or change of circumstances occur, which is so fundamental as to be regarded by law as striking at the root of the contract as a whole, it is the court which can pronounce the contract to be frustrated and at an end. The court undoubtedly has to examine the contract and the circuit under which it was made. The belief, knowledge, and intention of the parties are evident, but evidence only on which the court has to form its own conclusion whether the same circumstances destroyed altogether. So when in our contract, there is a recital clause saying that the dealership business of Maruti will be transferred to the plaintiff. When that dealership no longer is in force or is in existence because of the defendant's action of tendering resignation, that very basis on which the substratum on the basis of which the contract was formed ceases to be there. Because there's no dealership, then how can that contract be in there? So that was the thing. And another thing, I'm just developing a theology subject to me being correct. When a trial court has set aside or has held that the agreement is no agreement in the eye of law, and that finding has not been set aside by the appellate court, and the appellate court has not even gone into that area, that judgment gets merged with the appellate court judgment. Now we have a very weird situation. One, the court has held that the agreement is no longer there, but has held that I'm still bound to pay in terms of that agreement. Is the situation where it is now. That is a question that will subject to.
Where you have suggested that question?
Your Lordship, may see my question number 3 and 4 is what? Page 6. Whether when the substratum of an agreement that the fundamental landed foundation or core upon which a contract is entered into is completely eroded, and so also can be insisted upon merely in the absence of an exo. 6, 3, and 4. Let's see.
So what are the issues framed by the trial court?
The issues were, Your Lordship, may just give me a minute. Page number 2. Whether there is any cause of action for the suit, that Your Lordship will find internal page 19. Give me my page number, person, 19 too. Page 28. Six, 7, and 8 basically will the main issues. Non-joinder has been held against me for not airing Maruti Udyog. My case is that Maruti Udyog, against whom I'm not seeking any relief, nor am I making any prayer against them. So the question of pleading them as a party.
The thing is that they may not be necessary party, but maybe proper party.
To my understanding, subject to correction, they would not be a proper party also, because here nobody is disputing the factum of that they have not allowed the transfer. Nobody's case is that they allowed or it was the obligation of Maruti to do it. The position stand very concrete that Maruti has not transferred the dealership. So the only thing that the court was to examine was that without the transfer being effectuated, can the agreement be given effect to or not? It's like, Your Lordship, the government of India has declared the lockdown. Now, my case may be that I may not be able to perform the work because of the lockdown. I don't need to include the government as a party. Nobody is disputing the lockdown. In that context, it may be seen.
And you were insisting upon a substantial question of law number 3 and 4.
3, 4, and 1 has to be done because of the non-joinder. If it's not been, even if the 3 and 4 is decided in my favor, without 1 being decided in my favor, it will.
But you say if we frame this substantial question of law, we have to appreciate the evidence.
No, Your Lordship, because the law is very clear on that. There, it is not a requirement that we are not disputing on the facts. Facts are nowhere to be brought in. Here, it's a question of law that whether an agreement required for Section 56 to be applicable, whether as express stipulation.
This question of law number 1 does not relates to Section 56.
I'm 3 and 4. Sorry. 1 will be that whether in the case of no relief being sought for, when the factum of the termination is not in dispute, whether we require a party to be implemented. Nobody is questioning the factum of cancellation of the dealership by Maruti. What we are in on the effect of the cancellation.
No, you see, if we frame this substantial question of law number 1, then we have to go to the facts to answer this substantial question of law. And unless there is perversity, this court cannot reappreciate the facts.
Facts will be I understand, Your Lordship, but I'm just thinking what are the facts that will be necessary for answering this question? Because the fact that I believe will be necessary is only that whether Maruti has cancelled or not cancelled. There are 2 documents. Nobody is disputing that 2 documents. Admitted position. Nobody is disputing why Maruti has not given the thing. There's no question formulated, nothing on that. None of the issues were also on that. In that line, I'm saying that facts may not per se be involved in this. It will be only that whether any relief have been clear, whether the Maruti will be required for adjudication of deciding 3 and 4. Is the only question in my humble submission. So for that, facts may not per se be required to be gone into. But subject to what Your Lordship says. 1, 3 and 4, otherwise.
Okay, we'll pass the order. Heard Mr. Senapati, learned counsel for the appellant. Order reserved. We'll examine the matter first order.
File number 44.
May I please, the Lordship? Lordship, this matter was heard by the Honorable Court. The Lordships only day before yesterday. So,
Where is the judgments?
Lordship, yes. Our High Court judge. Regarding Jamamandi Lordship. Lordship, relevant portion, your Lordship.
Page number 5.
Page number 5, internal page 5, your Lordship. Doesn't mark, no? It isn't marked. May I read it up? Undoubtedly, at the time of settlement of Jamabandi, is prepared which records the name of the pattadar of the on the basis of the possession. Section 41(2), read with section 53 of the Assam Land Revenue Regulation raises a presumption regarding possession in favor of the recorded pattadar unless rebutted. This is 1952 Gauhati Lordship. The learned judge in deciding the matter did not consider this aspect of the matter, and I find that the non-consideration of these documents with regard to the presumption of possession and title is an error of law. I hold that these documents raises a valid presumption in favor of the plaintiff and that has not been rebutted by the defendant, and as such, this will be deemed to be correct as provided in the statute as indicated above. So in that case also, Lordship, Jamamandi was adduced. So our case also, Lordship, Jamamandi has been produced. Land revenue paying receipt, so GMC tax paying, Lordship, town municipal tax paying receipt has been produced. Their case is that, all right, this suit is barred because of adverse possession. They are admitting the title. It is not necessary, even then the document has been produced. So, learned trial court, your Lordship, now I am coming to the judgment considered by the learned trial court, that is 2007, 6 SCC 186. That is a case, your Lordship, what happened? This entire case was not read out by the learned trial court. That is a case, your Lordship, in respect of the ancestral property. This suit, initially, there's an ancestral property. Mr. X is one is a common ancestor. His 2 wives is there. And every day, each of the wife has 3 sons and 1 daughter. So, that the appellant before the Honorable Apex Court, the daughters, the legal heirs of the one of the daughter. The one of the son of the stepbrother, that is a stepbrother, he claimed that that your mother executed a will in my favor. That is response number 5 before the Honorable Apex Court. On the basis of the will, he got his name mutated. Will was challenged for cancellation. The civil suit is pending, but the revenue authority, what revenue authority did? Revenue authority mutated the name of response number 5 in the revenue records on the basis of the will. So that is why that was affirmed by the High Court that yes, his name is mutation is correct on the basis of a will. That was played before this Honorable Apex Court. Honorable Apex Court on that count said, now I am coming to the paragraph number 9, your Lordship. Only one part has been considered because that matter relating to the revenue record in pending before the revenue authority, not before the Honorable Civil Court. Lordship got it, para 9. There is an additional reason as to why we need to interfere with the order under Article 136 of Constitution. It is well settled that an entry in the revenue records does not confer title on a person whose name appears in records of right. It is settled law that the entries in the revenue records or Jamabandi have only fiscal purpose, payment of land revenue, and no ownership is conferred on the basis of such entries. So far as title to the property is concerned, it can only be decided by a competent civil court. So that mutation was done by the, so far this case is concerned, mutation was ordered by the revenue authority. And our case is pending before the civil court. So that part was not considered by the trial court. Trial court has considered that you cannot, on the basis of the revenue record, I cannot. Lordship, it is an ancestral property. We have exhibited of the document drawn in 1931, wherefrom I will brought the title document. And admittedly, that is not rebutted, that you are not the owner of the property. Because rather they said that no, this suit is barred under the Limitation Act because we are claiming adverse possession. If you are claiming adverse possession, you are admitting my title. Number one. Number two, in the subsequent paragraph, they have said, no, it is not your, it is railway land. So they are admitting it.
The defendants can take contradictory plea in their written statement.
They are contradictory plea.
They are entitled to take contradictory plea.
They are entitled.
Yeah,
They are entitled, but they have not proved it.
No,
that it is a railway
different
land.
matter. That is a different
So for
aspect.
the adverse person part is concerned, they are entitled, but that cannot be east and west, your lordship. One is admitting my title.
No, there are decisions of Supreme Court that a party can take contradictory
Yes.
plea.
Then when you have admitted this suit land is you are the true owner. And on the other hand, you are saying that it's a railway land. All right, they will prove their case. But no issue was framed. I am not on that, your lordship. But the trial court held that first they are said you are not the legal heirs of the Dhanlal Khetwat. Because Dhanlal Khetwat was our grandfather. That is from the document it reveals from the exhibit. And they are saying that the exhibited the documents, the Jamamandi is not the title deed. So that is why you cannot consider it as a title deed one. So our Honorable High Court says that if it is not rebutted, so the document of Jamamandi is a best document of title that can be considered. And the learned appellate court also.
Is it the finding of our High Court?
Lordship.
Is it the finding of our High Court?
It is our High Court, our finding. Our High Court finding, Lordship. So 2002 GLR. 2002-3 GLR 1, I have already supplied it. So internal page 5, your lordship. Lordship, I am reading out paragraph number 6 at internal page 4. Let us take up the first question of law formulated in the case. This is non-consideration of exhibit 2, 3, 6, 6.1 and 6.1 to 14. Exhibit 2 is a certified copy of Jamabandi. Entry shows that the name of Bonkidhar was mutated to his land, to this land by endorsement dated 24/1/1956 on the strength of a regular mutation, and it is mentioned there that this is by the way of sale. Exhibit 3 is the chitha for the land, and that also shows that the name of Bonkidhar Sharma was recorded there. Exhibit 4 is the patta for the land, and that also shows that the land stood in the name of Bonkidhar Sharma. Exhibit 5 is another patta for the land. Exhibit 6.1 to 6.14 are the land revenue paying receipts for the land. Exhibit 7 is the order by which the mutation order was cancelled. That was void order dated 1998. That is after about 30 years of the order of the mutation. Section 40 of the Assam Land and Revenue Regulation provides for records of right. the settlement officer has to frame for each state a record of right in the prescribed manner. The note appended to the sections. Lordship got it. The note appended to the section shows that the records of right is the Jamabandi based on Chitha and the field map entry is the record of right are to be founded on the basis of actual possession. Undoubtedly, at the time of settlement, the Jamamandi is prepared, which records the name of the Pattadar on the basis of possession. See, here 1967 Gauhati. Section 41(2). Read section 53 of the Assam Land Revenue Regulation raises a presumption regarding possession in favor of the recorded Pattadar unless rebutted. That is 1952 Gauhati. The learned judge, in deciding the matter, did not consider this aspect of the matter, and I find that non-consideration of these documents with regard to the presumption of possession and title is an error of law. I hold that these documents raises a valid presumption in favor of the plaintiff, and that has not been rebutted by the defendant, and as such, this will be deemed to be correct as provided in the statute as indicated above. That is the law laid down by our Honorable High Court.
No, that's all right. But here, it has been said that a presumption can be drawn on the basis of those documents. But it has not been held that those are title documents.
No, it is not said. Presumption can be. Now the question is whether our document has been rebutted.
No, Mr. Bhuya,
Lordship.
just before few minutes ago, you have submitted that these are the title documents.
I am not on that, Lordship, unless it is rebutted, that it can be presumed as a title document. Now, Lordship, one thing, I am the owner, my predecessor was the owner of 1 bigger 3 kotha 10 lesser of land. And out of that, I filed the suit for 2 kothas. The remaining is still in possession. What will the consequence, your Lordship? That is to be considered. My case is that my predecessor was the 1 bigger 3 kotha. Out of that, 2 kotha is my suit land. That has not been challenged by anybody. There is no counterclaim by the defendants. You are not the owner of that land. There is no counterclaim.
So, before the trial court, there were 4 issues.
Lordship.
And issue number 3 is the relevant.
Lordship.
And how the appellate court has dealt with that issue?
Lordship, I am coming. Issue number 1 is whether there is cause of action. 2 is whether the suit is maintainable. 2 issues decision has not decided in our favor. Issue number 3, whether the plaintiffs have right, title, and interest over the suit land, and whether the plaintiffs are entitled to decree as prayed for.
So, issue number 3 is the crux of the matter.
Both 2 issues are decided together. And whole that you have only exhibited the documents, the Jamamandis, so it is cannot be considered a title document. So you could not prove the title over the land. So that is why my suit was dismissed. And I am not entitled to get the relief. And this issue has been upheld by the appellate court.
Okay. Heard. Mr. R.K. Bhuya, learned senior counsel, assisted by Mr. Singh, learned counsel for the appellate. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 30th January 2026, passed by the learned civil judge, Senior Division Nagaon, which indicate herein after First Appellate Court in title appeal number 13 of 2023. It is to be noted here that by the impugned judgment and decree dated so and so, the learned First Appellate Court has affirmed the judgment and decree passed by the learned Civil Judge Junior Division number 2 dated 26/7/2023, passed in title suit number 79 of 2012. It is also to be noted here that by the judgment and decree dated 26/7/2023, the learned trial court has dismissed the case suit of the plaintiff. Where is the memo of appeal?
Lordship.
The grounds mentioned therein. And also, where is the impugned? No, where is the impugned judgment and decree dated so and so, passed by the learned First Appellate Court and also by the learned trial court. And also carefully gone through the suggested substantial question of law. This appeal is admitted on the following substantial question of law. Number 1. Whether the finding recorded by learned courts below in respect of issue number 3 without considering Exhibit 1, the Jamabandi, and Exhibit 10. What is Exhibit 10?
1 to 10, Lordship, all Jamabandis.
Exhibit 1 to 10, the
Lordship, all-
Jamabandis, which gives rise to a presumption of title in favor of the appellant, no, in favor of the plaintiff, in favor of the plaintiff, in view of section 41 with regard 2 of the Assam Land Revenue Regulation. The court may also consider framing of any other substantial question of law at the time of hearing, if found necessary after notifying both the parties. Justice shall call for the records from the learned courts below. Should notice to Agota Diva notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process written today. List after 4 weeks. So you have not exhibited the revenue payment receipt?
Yes, already exhibited. This was exhibited. Lordship, from this Jamabandi, or sorry, from judgment, it will
1
be
to 10, it is a Jamabandi.
Lordship. The exhibit 11, your Lordship, municipal tax, exhibit 11 and series, certificate of municipal tax paying receipts, exhibit 12, certificate of land revenue paying receipts.
Exhibit
11 and 12.
11 and 12. Along with exhibit 1 to 5. List after 4 weeks.
45.
Obliged.
May I please your lordship, my lord. The anonymous case is also regarding specific performance of the contract, my lord. And it was a concurrent finding against us, my lord. Substantive question, kindly see page 3, my lord. Basically, 2 substantive question I will educate, my lord. Section 67. But the first one, these appeal raises a substantial question of law as to whether the respondent plaintiff had duly proved their continuous readiness and willingness or demonstrated sufficient to perform the part of the contract under the written agreement dated 1/10/2020 as mandated under section 16C of this specific agreement. Now, my lord, here in this case, my lord, only the plaintiff will suffice, my lord. Because section 16, my lord, just I'll read one line, my lord. Specifically mentioned, my lord. 16C, who fails to ever my statement has to be made, my lord, and prove that he has performed or has always been ready and willing to perform essential terms of the contract, which are to be performed by him, other than the terms of the performance of which has been prevented or waived by the defendant. The plaintiff is there. I have a next, my lord, 2-page plaint, my lord. Next question, my lord, perversity will come. I will just write 3 lines here. Because their claim is that, my lord, an agreement was signed, my lord. Subsequently, it has been extended by other agreement, my lord. But those we disputed, my lord. And those were sent for handwriting expert, my lord. Handwriting expert doubted, my lord. That has been found in both the title suit judgment as well as the trial court judgment as well as the appellate court judgment. Page 22, my lord. I'll read 4 lines. Page 22, last paragraph, my lord. I'll read, my lord. That is one of the issue, my lord, issue related whether defendant has executed the Bainama 30/10/23, my lord. I'll read the last paragraph. As the defendant disputed the signature in Exhibit 3, Exhibit 3 is the Bainamas, extended Bainama. To be their forced signature in Exhibit 1 and 3, were the first sent to FSL Kahilipara, Gauhati for examination and opinion as to whether the signature of the defendant in both the 2 documents, that is the second Bainama, first and second Bainama, are handwriting of the same person or not. Senior scientific assistant of FSL reported after examination of both the signature are there in the Exhibit 3, and they are of the same person, that is from Kahilipara. But the defendant are not satisfied with the report of FSL. They again prayed for sending their signature, next page, my lord, for examination by All India Forgery Detection and Fingerprint Bureau, and accordingly this could allow their prayer. Exhibit 1 and 3 were sent to All India Forgery Detection and Fingerprint Bureau, Agra, for examination by expert, other comparison and examination. The examiner questioned the document, opined that the signature of Exhibit 1 and Exhibit 3 are not the same person. So this purpose is apparent, my lord. If this second part of the extended agreement goes, my lord, their suit for a specific purpose will go, my lord. Even then, the court believed the earlier version, my lord, and allowed the suit. Appellate court also had held.
No. Expert opinion cannot be
Yes. Only corroborating.
Yes.
Understand. But even then, it's apparent, my lord, that my signature has been forged by them, my lord. Well, how a person forged my signature is entitled to relief, my lord. Equitable relief, my lord. How he will get, my lord? How he is entitled to decree, my lord? That means he must have made false statement, my lord. Is he not guilty for making false
you
statement?
say in that respect, there is concurrent finding of fact.
Yes, I understand that. But this is that is perversity, apparent perversity. Apparent. That is apart from 16C, my lord, regarding the mandate of the specific performance, where this statement are required to be made, my lord. This is the second one, my lord. This is the regarding perversity, my lord. My first question will be 16C, my lord. That in plaint is there, my lord. 2-line plaint, I can read, my lord. Nowhere it is stated that they are willing to perform their part, they have complied their part. These are not there, my lord. It is there, my lord. I can read. So these 2 part, my lord, I think your lordship may require to interfere, my lord. Because here the finding, these are findings of the court below, my lord. Finding of the trial court.
Let us see the plaint.
Yes.
Page number.
Annexure 1, page 6, my lord, is the translated copy, my lord. Only 2 pages, I will read, my lord.
No, not necessary to read entire pages.
Kindly see, my lord,
relevant portion.
from page 7, my lord. Yes. Next page, page 7. 3, my lord. The arranging the remaining consideration within the stipulated period 1 month extended actually. The plaintiff verbally asked the defendant to execute the final registered sale deed in respect of the land in their favor, but the defendant delayed in doing so, and as the validity of the agreement of sale was going to be expired, the plaintiff sent legal notice on 2012-2004, requesting the him to remain present. Kindly see, my lord. He is given legal notice, directing me to be remain present in the office of the sub-registrar, my lord. Is it the way, my lord, suit for a specific purpose? This is the precondition of the suit for a specific purpose. He is to approach, my lord. He has to demand me or request me. Kindly see.
No, can it be interpreted that by issuing advocate notice
Yes.
to remain present in the sub-register office?
And register it.
He has not approached you.
And all these things are well, in the registration of land, my lord. Lot of things are necessary. Permission is necessary. But it is not a matter of joke, my lord. Here, I've seen, my lord, for selling and purchase of land, it takes 1 year, my lord. By obtaining permission, my lord. How, my lord? Kindly see, my lord. Registered notice, sent a registered notice to the defendant on 2012-2004, requesting him to be present at 10 a.m. to 4 p.m. in Hailakandi, Kachari, before Mohori, petition writer, so and so, to execute and register the sale deed. Is it, my lord, general agreement, my lord? It is a cooked up case, my lord. That is why it is drafted like this, my lord. That advance inference also can be brought.
We cannot go into that aspect.
Because, my lord,
already both the courts below discussed the issue and arrived at a finding, concurrent finding of facts.
I understand, my lord. That is why we have challenged it, my lord, because my handwriting has been, I have disputed my handwriting in the, not in the first, but in the second Bainama, my lord, deed of agreement, my lord. And that has been approved from Agra, my lord, that this is not my handwriting, my lord. Apparently on record, my lord, it is proved, my lord, that the handwriting in the second Bainama is not my handwriting. That is apparent. That is on record, my lord. Here also, preponderance of probabilities cannot be dragged into that extent, my lord. Where a false thing can it be altered into a true thing, my lord? Can a right can be altered into wrong, my lord, or wrong can be altered into right, my lord, only by dragging the legal aspect of preponderance of probabilities, my lord? Cannot be, my lord. My name is Mr. Chaudhary. I am Mr. Chaudhary. I cannot be Mr. Bhatt, my lord. This is not a perversity, my lord. The appellate court finding, my lord, on this issue, my lord. Kindly see page 40, my lord.
When the agreement was executed?
Yes. 1/10/2003, my lord. First agreement.
And when they have approached you for performing your part of contract?
Yes, sir. Yes. They approached, my lord. Because they are saying subsequently the other agreement was there, which we denied.
How many agreements are there?
Two agreements.
Two agreements.
First agreement, of course, we admit, my lord.
No,
But
specific performance is sought for in which agreement? First
both,
one or second?
both, my lord.
Both.
1/10/2025, my lord. 2003, my lord. 1/10/2003, my lord. It plain, my lord, is there in the first paragraph, my lord. Executed 1/10/2023, executed deed of agreement for sale in respect of the scheduled land in favor of the plaintiff by fixing 48,000, my lord. We are admitting this, my lord. Proper consideration on receipt of ₹25 as the earnest money from the plaintiff and assurance that they would it would be executed the sale deed in respect of within 1 month, which they did not. Then they have forged that document, my lord. That is in paragraph number 2. It is there. An advocate notice was sent on 2012-2004, my lord. Initial Bainama, my lord, 1 month time was given. Within 1 month, it is to be done. And can you see advocate notice that 2012-2004, my lord? That is also after 2 months. A lot of things are there, my lord, in this case. And section mandate of section 16C, my lord, this is important, my lord. Specific relief act, my lord.
No, is it your case that after the 1 month, the plaintiff is not approaching?
Yes, my lord. Yes. Can you see, my lord, our written statement is there, my lord.
Page number?
Annexure 2, 2, my lord. Page number 12 onward.
12.
12, my lord. Actual fact, that is paragraph number 5, my lord. The same page, my lord. The actual fact is that out of necessity, when the defendant intended to sell some land, very important, we agreed, my lord. Plaintiff agreed to purchase the same. Accordingly, value was fixed at 48,000, of which 25,000 the earnest money of the paid, my lord. And the defendant executed the agreement for sale on 1/10/2003 with the condition that on receipt of the remaining consideration amount of rupees 23 from the plaintiff, the defendant would execute the final registered sale deed in respect of the scheduled land in favor of the plaintiff within 1 month. And if the plaintiff failed to give the remaining consideration within stipulated time to get the registered deed in respect of the land executed in favor, they would not be entitled to demand the earnest money. It was there in the agreement, my lord. Since that has been passed, my lord, so they prepared one more thing, the other agreement.
So they have issued the notice within 1 month?
No.
Advocate
They
notice?
issued the
Only on the receipt of the advocate notice.
Or after 1 month?
that is yes. That is on that notice on, my lord. That notice it is in the plain. Yes, I'm just yes. 1/10/2012. 2012-2004. 2012-2004.
After?
After yes. After 3 months.
After 3 months.
3 months.
But the period stipulated in the agreement for
1 month.
execution of the sale deed is 1
30
month.
days, 1 month.
So they have approached you only after 3 months.
After 6 months, actually it comes 5 months. 5 months.
5 months.
5 months. It will come 5 months.
So your contention is that they are not continuously ready and
Yes,
willing
yes.
to perform
Yes.
their part of the contract.
Yes. And that is covered by section 16C.
Yes.
That is one part, my lord, one substance question. Other substance question, just I have mentioned, my lord, regarding this, because we said the subsequent agreement, what they have shown, my lord, in the case, my lord, that has been forged, and that has come on record also. That has come on the in the finding also. So these aspects also can be your lordship may consider, may
No,
adjudicate this
whether
matter.
any issue was framed by the trial court or the first appellate court in that regard, in respect of the second agreement.
My lord, yes. They have relied upon page number 20, your lordship. Point 4, my lord. Page number 20, paragraph number 4, my lord. They relied all these witnesses, my lord.
No, whether any issue was framed.
Issue, my lord, general issue, my lord.
Page number 20.
No, it was framed.
This is the issue. Para 4 is the issue.
Yeah, para 4, my lord.
Page number 20.
Page number 20, my lord. Whether the defendant on receiving another amount of 10,000 in advance, down below, my lord. This is one of the issue. 30 and 20 executed Bainama by enhancing the stipulated period of earlier. That is one of the issue, my lord.
Is it 110?
In that issue, my lord, this handwriting came, my lord. In this issue, my lord.
No, whether you have taken the plea that the second agreement is a forged agreement.
Yes, we denied it. Yes, we did. That is our case itself.
Just above. Page number 20, second paragraph. Middle. Page number 20, second paragraph. So, thereafter, 1 year later.
My lord, in this paragraph itself, my lord, just above, my lord. will show, my lord, that thereafter 1 year later, they have received summons from the court in the instance that they have come to know that the plaintiff have prepared a false bindama. Kindly see, my lord. But later on, we come to know, in the written statement also we have taken this down, my lord. That is.
Written statement also you have taken the play.
Yes, yes.
Where? In voice paragraph?
Yes, my lord. In the paragraph number 5, my lord, down below, my lord. I've just read, my lord. Page 12, that actual fact is that, my lord, that is to 25,000 we have taken is all right, my lord. I'll read last 4 lines, my lord. The plaintiff failed to give the remaining consideration within the stipulated time to get the registered deed in respect of the executed in favor, they would not be entitled to get earnest money. Accordingly, defendant made many efforts to receive the balance amount consideration from the plaintiff and to execute the final registered sale deed. But they did not come. The paragraph number 6, my lord. After 1 year, the notice, the defendant have came to know about the plaintiff in collusion with Mohori and the witnesses fraudulently created the deed. We have taken specific ground, my lord, and that has been also come under discussion in the trial court judgment.
Mr. Hawk.
The first agreement was made. The period now stipulated was 1 month. That is why second agreement was made. And it scribes and witnesses will also examine. And the matter was referred to the Gauhati for forensic lab. And it is said is that exhibit 2 and exhibit 3, the two signature of the defendant are same. Then they dissatisfied. Then it was sent to Agra. When it was sent to Agra, it was not sent that two documents. One document, my lord, that disputed signature, and other signature is signed on that date, and it was sent after 10 years of that agreement, 2000, possibly 10 or 13, after 10 years. That is the findings of the appellate courts. It was not contemporaneous. That is why the signature was different. That is why in Agra lab, it was, my lord, said that these two signatures were not same. That is the issues. And your lordship can be seen in appellate court judgment.
So after 10 years,
They put signature, it was sent to the Agra. And then both that is exhibit 2, exhibit 3, so that is first agreement, second agreement, that was sent, and then it is safe. That is the question. So far is the agreement is that they cannot. It is not a fault. That is
no,
not-
regarding this continuous readiness and willingness on your part to perform your
After 1 month, when my lord, they did not, my lord.
proceed.
Then another agreement was made. And that agreement was that the 3 years to be completed.
Entire process.
Within that period, my lord, we send the advocate notice to the defendants. It is within that, and that issue was spread, whether it is time barred or not. It is not time barred.
As per second agreement, time was extended to 3 years.
3 years.
3 years or 3 months?
3 years. Up to 31/12/2004.
1 year. 1 year extended.
It is
not 3 years.
Yes, it's 1 year. But it is within time, the
Legal notice was issued.
notice was on 20/12/2004. It was
No,
So-
but what was stipulated in the second agreement?
that within 31/12/2004, it should be completed. Time was the essence at that point of time. But they did not come. So we sent the advocate notice. And that was the issue was also friend. Whether it is time barred or not. It is in favor of the plaintiffs. So far the forgery, it is proved that no forgery. In the appellate courts also it is discussed. That second state report of the Agra. So discussed. It is not the process that you put signature after 10 years signature. It can
It is not absolutely false. They should not make such a statement. Nowhere is mentioned is after 10 years. Afterwards, marriage it is written. You
afterwards.
should not say like this. 10 years and afterwards is different.
My lord, page 43, your lordship kindly see the findings of the appellate court.
No, If there is already one opinion from the FSL Guwahati,
In favor.
why the matter was again referred to?
Disputed. Definitely disputed. Then it was.
So after how many years?
Not how many years, my lord. It is written afterwards it is said, my lord. No year and month has been mentioned, my lord. Immediately said, my lord. It has been sent from the court, my lord, from the office, my lord.
Obviously.
Office will not, office, the appellate court office will not make any false
Findings of the.
Formally it was there.
It is one, furthermore, if we go by the settled position of law, we find that as per settled position of law, if we have several judicial forms, the disputed signature are to be compared with the admitted signature which was contemporaneous in nature and not with the admitted signature obtained subsequent to the date of disputed signature. That is the findings of the appellate court in respect of their way.
I've not seen 10 years. At least 10 years also.
We would give a judgment as a discuss policy. Specimen signature.
In page 40 paragraph, last paragraph, it is also says comparison of the signature, those were taken on separate sheets. Were taken after a much belated stage. Moreover, section 73 also, my lord, the bishop. That Agra, that is a private institution, that is my lord reflects in it. That is a private institutions.
Okay, we'll again list it on Monday for further consideration. So your contention is that only one substantial question
Yes,
of
yes,
law.
will do.
That is in respect of 16C.
16C. And this is additionally argued, my lord, since it is there in the finding of facts, my lord, perversity I brought. Ultimately, this will interconnected, my lord. Because they have relied, their entire case relied upon the subsequent agreement, which I denied and the Agra report came in my favor. So that aspect is required to be considered. my lord. That is
No. Already one agreement is there.
Yes, that is there.
And
That is the
one
lapse.
report of the forensic science laboratory is there
Huh.
in their favor.
Huh. But that is my signature. I am admitting the first one.
Mm.
First signature is mine.
No. There are two opinions.
Yes.
One is of the government. One is from the laboratory under the government, and the other is private.
But that is very reputed, my lord.
Which one?
That Agra one.
Maybe.
It is sent from the court,
Maybe.
my lord. That is sent from the court itself and
No.
not by private way.
First, you have to establish a cause and reason
Yes.
to discard the
This
report
one,
submitted by the
my-
government,
Yes.
by the laboratory under the government.
My lord. Yes, if it goes, then section 16C will remain. Otherwise, both. I'll try, my lord, next date.
Heard Mr. A. Chaudhary, learned counsel for the appellate, Mr. Hawk, learned counsel for the respondent. Heard in part, list the matter on Monday next. Can it be on Wednesday then? Mr. Chaudhary, on Wednesday? Next Wednesday?
All right.